Section 13 of Magna Carta Commemoration Essays. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Maria Kasper. The Influence of Magna Carta on American Constitutional Development by H.D. Hazeltine. Parts 2, 3, and 4. Part 2. By the close of the colonial period, principles of Magna Carta, adapted to social and political conditions in the American communities, had become firmly embedded in their systems of law and government. In the Revolutionary epoch, extending from 1760 to 1783, these principles, as part of the whole body of English constitutional law, claimed by the colonists as English subjects, were to enter upon a new phase of their American history. The years that immediately preceded the outbreak of war in 1775 and the Declaration of Independence in 1776 were characterized by a momentous controversy between the colonies and the mother country over constitutional principles. The doctrine that the colonists had all the rights of Englishmen had more and more strenuously asserted itself throughout the 18th century. At last, the claims of the colonists were largely focused in the demand that there should be no taxation without representation, a principle which they held to be based on firm English foundations. As the controversy increased in intensity, the colonists appealed less to the guarantees of the royal charters and more to the principles of the common law, especially the principles contained in Magna Carta, the Bill of Rights, and other documents of English liberty, in support of the views which they so strenuously asserted in opposition to the position taken up by Crown and Parliament. In the 10 years just before the war, there was indeed a marked tendency, evidenced by all the great state papers, such as the Massachusetts Circular Letter of 1768, the Virginia Resolutions of 1769, the Declaration and Resolves of the First Continental Congress of 1774, the Declaration of the Causes and Necessity of Taking Up Arms, 1775, and the Declaration of Independence, 1776, itself. To base colonial rights on political and legal fundamentals to be found in the law of nature and the English Constitution. The colonists looked upon the English Constitution as their own, and revered it as the embodiment of their rights. The common rights of Englishmen formed the shield behind which they resisted what they held to be attempts upon their liberties. When the war at last came, it was fought out by the colonists in defense of what they held these rights to be, rights won in England in the long struggle for the rule of law, and embodied in the doctrines of common law, especially in the principles of Magna Carta, the Bill of Rights, and other English documents that visualized for the colonists their claims for freedom as opposed to tyranny. Thus it resulted that the controversy between England and her colonies, and the war that followed it, were largely caused by differences of opinion as to constitutional and legal questions, and that in the struggle of the colonists for what they looked upon as their rights, Magna Carta, as one of the fundamentals, as part of the legal inheritance, the birthright of Englishmen at home and in the colonies, played a role of great prominence. Footnote. The American theory was summed up by Otis in one of the earliest, 1764, political pamphlets of the Revolution. Every British subject born on the continent of America is, by the laws of God and nature, by the common law, and by act of Parliament, entitled to all the natural, inherent, and inseparable rights of our fellow subjects in Great Britain. See Channing, The United States of America, page 45. To what extent, if any, Magna Carta alone and of itself gave the colonists a basis for their version of the principle that there should be no taxation without representation, may be seen by a perusal of McKechnie, Magna Carta, 2nd edition, 1914, pages 231 to 240. End footnote. In considering the constitutional aspects of the Revolutionary epoch, it should never be forgotten that since the early 18th century, the institutions of England and of the colonies had been drifting apart, and that the colonists, unlike their kinsfolk in the mother country, did not recognize the doctrine of the supremacy of Parliament as an imperial legislature. In one highly important point, therefore, we find that the American Revolution was like the English Revolution of 1688. In England, powers of the king, asserted to be based on legitimate foundations, were destroyed. In America, powers of Parliament, unquestionably legal in character, were forcibly repudiated. Fundamental differences of opinion in regard to the authority of Parliament naturally affected the views of Englishmen at home and in the colonies as to the nature of constitutional rights and liberties and the interpretation to be placed upon constitutional documents such as the Great Charter and the Bill of Rights. Part 3. In respect of private law, the Revolution resulted in no break with the past. After, as before the Revolution, the common law, adapted and modified by its American environment, formed the general basis of private rights, and this feature of American law survives to the present day. So, too, in the matter of constitutional institutions, the Revolution made less difference than is sometimes imagined, for in many of their main characteristics, the federal and state governments of the national era followed precedents of the colonial and revolutionary epochs. Thayer, in his essay on the American doctrine of constitutional law, sums up the Revolution in 2 short sentences. The Revolution came, and what happened then? Simply this: we cut the cord that tied us to Great Britain, and there was no longer an external sovereign. That the federal and state constitutions contained vitally important features that were distinctively American as opposed to English is one of the commonplaces of political history. The institutional divergence from English models which set in, as we have already observed, during the early 18th century, was sure to produce ultimate results very different from some of the leading features of the English Constitution. The federal nature of the Union, the sanctity of the written Constitution as a document embodying the fundamental law, the coordination of the legislature, executive, and judicature as the 3 departments of government, which operate in distinct spheres and enjoy equality of position, the remarkable power of the judicature to declare an act of the legislature that conflicts with the written Constitution null and void. These are 4 of the main characteristics which mark a wide gulf between American constitutional institutions and the unwritten Constitution of England, under which Magna Carta and the Bill of Rights, although of fundamental significance, are yet subject, like any ordinary statute and the decisions of the courts, to the legislative sovereignty of Parliament. But in at least one highly important respect, the American constitutions display a striking adherence to the traditions of the English Constitution. In the Bill of Rights, which forms a part of each of the written constitutions, both state and federal, there is a persistence of those fundamental rights of Englishmen embodied in Magna Carta, the Bill of Rights of 1689, and other leading sources of the common law. This whole development is summarized by Sir Frederick Pollock in one sentence of The Genius of the Common Law. Our fathers labored and strove chiefly in the field of crown law to work out those ideals of public law and liberty which are embodied in the Bill of Rights and are familiar to American citizens in the constitutions of the United States and of their several commonwealths. It is this American Bill of Rights, forming an important element in constitutional law, as distinct from constitutional institutions, which chiefly links the American constitutions of today with the Magna Carta of 1215. 1. As the direct descendants of the royal colonial charters, these charters being based on still earlier models, the state constitutions are the oldest feature of American political life. Nearly all of the original 13 colonies, when they declared their independence and framed their state constitutions, included in these documents, as perhaps their most important feature, a declaration of the fundamental rights and liberties of man. Most of the clauses of this declaration, known collectively as the Bill of Rights, were taken over from colonial and revolutionary laws and constitutional documents, the contents of which, in turn, as we have already seen, had been derived originally, in important particulars, from Magna Carta, the Bill of Rights, and other great constitutional statutes which secured the liberties of Englishmen. As new states have been admitted into the Union from time to time, they too have embodied a Bill of Rights in their constitutions. In this way, therefore, the Bill of Rights of the state constitutions traces its pedigree back to Magna Carta. In each separate state of the Federal Republic, as in England, the Great Charter of 1215 still exists, protecting men in their lives, liberties, and estates from the encroachments of arbitrary or tyrannical government. Footnote: Bryce, American Commonwealth, 1910, Volume 1, pages 426 to 463, gives a summary account of state constitutions and their history. On page 438 he says, "The Bill of Rights is historically the most interesting part of these state constitutions, for it is the legitimate child and representative of Magna Carta, and of those other declarations and enactments, down to the Bill of Rights of the Act of 1 William and Mary, Session 2, by which the liberties of Englishmen have been secured." End footnote. Naturally, the state constitutions vary in the form of words chosen to express the rights and liberties derived from Magna Carta. Some constitutions, more especially perhaps the earlier ones, follow the original model closely. Others are couched in terms more suited to American conditions. But the main features of the original are in all cases retained in the American derivations. So, too, the constitutions vary one from the other in the extent to which they borrow from the Great Charter. Some take more and some less. But in all are to be found, in one phrasing or another, the essence of Chapter 39. Thus, to cite only one illustration, in Section 16 of the Constitution of the new State of Oklahoma, 1907, Chapter 39 of Magna Carta appears in the phrasing, "No person shall be deprived of life, liberty, or property without due process of law." 2. The Federal Constitution of 1789, including the amendments of 1791 and of later times, is likewise derived in part from the colonial charters and from other constitutional and legal sources of the colonies and of England. In Lord Bryce's felicitous words, "The American Constitution is no exception to the rule that everything which has power to win the obedience and respect of men must have its roots deep in the past, and that the more slowly every institution has grown, so much the more enduring is it likely to prove. There is little in this Constitution that is absolutely new. There is much that is as old as Magna Carta." The Constitution of 1789 embodies, in one article or another, various declarations of the fundamental rights of men. Thus, for example, it provides for taxation by the legislature only, for the privilege of the writ of habeas corpus, for trial by jury in criminal cases, for the prohibition of bills of attainder, ex post facto laws, laws impairing the obligation of contracts, and laws imposing religious tests. These and other provisions, derived in large measure from English and colonial precedents, constitute a body of constitutional guarantees of the highest value. But the absence of a formal Bill of Rights, similar to the one included in state constitutions, was at once severely criticized by the people as a feature of the Constitution dangerous to their liberties. Footnote: Some of the leading statesmen held that same view. Thus Jefferson said, I hope that a declaration of rights will be drawn up to protect the people against the federal government, as they are already protected in most cases against the state governments. Jefferson seems to have had in mind the Bill of Rights embodied in state constitutions. End footnote. In response to persistent demands, 10 amendments, taking effect in 1791, were added to the original instrument. These first 10 amendments, which are to be viewed as a supplement or postscript to the original Constitution, and not as an alteration of it, make up what is called, after the English and earlier American precedents, the Declaration or Bill of Rights. In essence, this Bill of Rights secures the rights and liberties of the individual citizens and the separate states against the encroachments of the federal government. Although each of the amendments added to the Constitution after 1791 demands separate consideration, both in respect to its general scope and the place it holds in the whole body of the Constitution, yet we may regard the 13th, 14th, and 15th Amendments, in certain of their fundamental characteristics, as later additions to the Bill of Rights contained in the first 10 amendments. It is said that the people regarded the liberties embodied in the first 10 amendments as their own because they were based on Old English law. Certainly a study of the amendments reveals the fact that the origin of some of their features is to be traced to the common and statutory law of England. Certain of their clauses are undoubtedly based directly or indirectly, through colonial and revolutionary precedents, upon Magna Carta, the Bill of Rights, and other English constitutional documents. Thus, upon Magna Carta rests the provision in the Fifth Amendment that no person shall be deprived of life, liberty, or property without due process of law. Similarly, the 14th Amendment, 1868, in declaring that no state shall deprive any person of life, liberty, or property without due process of law, adopts, like the Fifth Amendment, the 39th chapter of Magna Carta. The last clause of the First Amendment, which provides that Congress shall make no law abridging the right of the people to petition the government for a redress of grievances, seems to go back for its origin through various American documents to the English Bill of Rights. So, also, upon the English Bill of Rights is based the Second Amendment, which declares that a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. In the words of Judge Cooley, the amendment, like most other provisions in the Constitution, has a history. It was adopted with some modification and enlargement from the English Bill of Rights, where it stood as a protest against arbitrary action of the overturned dynasty in disarming the people, and as a pledge of the new rulers that this tyrannical action should cease. Again, the Eighth Amendment is almost an exact transcript of the clause in the English Bill of Rights, which provides that excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The Eighth Amendment reads, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." These and other provisions in the Federal Constitution rest upon the constitutional law of England. Magna Carta's contribution to the federal instrument and to the state constitutions consists fundamentally in the adaptation of the famous Chapter 39 to meet American conditions. This chapter had been embodied in colonial law. By its incorporation in state constitutions and in the 5th and 14th Amendments to the Federal Constitution, it still serves as the basis of the rule of law throughout the Republic. 3. Legal and historical accuracy may well be placed in jeopardy by considering the due process of law clauses apart from their full setting in the amendments and in the whole scheme of fundamental law as set forth in the complete federal instrument. But with this caution, a few words in explanation of the meaning and scope of the clauses may be ventured. The last words of the Fifth Amendment, 1791, declare that no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. The last portion of Section 1 of the 14th Amendment, 1868, reads, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." American political and constitutional history of absorbing interest and moment surrounds every word of these due process of law clauses. Suffice it here to say that the prohibition of the Fifth Amendment was introduced as a check upon the federal government as distinct from the state governments, while in the 14th Amendment, adopted after the great Civil War between the North and the South, the prohibition is directed against the individual states that compose the Union. Thus, the two amendments, under the dual government inseparably incident to American federalism, supplement one the other. Together, the amendments ensure to the people their individual rights to life, liberty, and property under the rule of law, as opposed to arbitrary and tyrannical action on the part of either state or federal governments. The due process of law clause of the 14th Amendment represents, therefore, the latest obligation of America to Magna Carta. Indeed, as Judge Dillon, in commenting on the constitutional guarantees of the two amendments, remarks, "This was not new language, or language of uncertain meaning. It was taken purposely from Magna Carta. It was language not only memorable in its origin, but it had stood for more than 5 centuries as the classic expression and the recognized bulwark of the ancient and inherited rights of Englishmen to be secure in their personal liberty and in their possessions. It was, moreover, language which shone resplendent with the light of universal justice, and for these reasons it was selected to be put into the Fifth Amendment of the Federal Constitution, as it had already been put into the charters and constitutions of the several states. It was of set purpose that the prohibitions of the 14th Amendment were directed to any and every form and mode of state action as opposed to federal action, whether in the shape of constitutions, statutes, or judicial judgments, that deprived any person, white or black, natural or corporate, of life, liberty, or property, or of the equal protection of the laws. Its value consists in the great fundamental principles of right and justice, which it embodies and makes part of the organic law of the nation. It will hereafter, more fully than at present, be regarded as the American complement of the Great Charter, and be to America, as the Great Charter was and is to England, the source of perennial blessings. Footnote: Adams, Origin of the English Constitution, 1912, page 243, in commenting on Chapter 39 of Magna Carta, remarks, "What was then, 1215, demanded was a trial according to law, and securing to them, the barons, their legal rights. Taken in this sense, Clause 39 of Magna Carta would correspond somewhat closely to the general prohibition included in Amendment 14 to the Constitution of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law." End footnote. The Supreme Court of the United States has never attempted to give a rigid and complete definition of due process of law. The policy of the court has been expressed in the recent case of Twining v. New Jersey. This court has always declined to give a comprehensive definition of it, and has preferred that its full meaning should be gradually ascertained by the process of inclusion and exclusion in the course of the decisions of cases as they arise. There are certain general principles, well settled, however, which narrow the field of discussion and may serve as helps to correct conclusions. These principles grow out of the proposition universally accepted by American courts on the authority of Coke, that the words due process of law are equivalent in meaning to the words law of the land contained in that chapter of Magna Carta which provides that no free man shall be taken or imprisoned or disseized or outlawed or exiled or in any wise destroyed, nor shall we go upon him nor send upon him but by the lawful judgment of his peers or by the law of the land. In Hagar versus Reclamation District, the court had already expressed the view that the meaning of due process of law is that there can be no proceeding against life, liberty, or property which may result in deprivation of either, without the observance of those general rules established in our system of jurisprudence for the security of private rights. So, too, in Bank of Columbia versus Oakley, it was said, "As to the words from Magna Carta, after volumes spoken and written with a view to their exposition, the good sense of mankind has at length settled down to this, that they were intended to secure the individual from the arbitrary exercise of the powers of government, unrestrained by the established principles of private right and distributive justice." Although the due process of law phrase is thus historically derived from and closely related to the phrase per legem terrae of Magna Carta, nevertheless, in the application of the clause to the institutions of government in the two countries, there is a marked difference between the Constitution of England and that of America. In England, the provisions of Magna Carta, including Chapter 39, were originally intended, and have since been regarded, as a limitation upon the executive and judicature, not upon the legislature. In English law, Chapter 39 is held to mean that no person is subject to the arbitrary acts of the Crown or its courts, that no person shall be deprived of his life, liberty, or property unless in accordance with the existing law of the land, whether it be common law or statutory law. Parliament is not affected by the limitations imposed on the Crown and the courts. Legally, the Parliament is the sovereign power, and can at any moment alter the law of the land by its enactments. The rights of the individual are in theory and in practice subject to the supreme legislative power of Parliament. As this legislative supremacy of Parliament was fully established by the time of the adoption of the 5th and 14th Amendments, it might be contended that historically their due process of law clauses were not intended to operate as a limitation upon the powers of the state legislatures and of the federal Congress. But American constitutional government, both state and federal, is based on written instruments, which in the sphere of political and legal activity are fundamental and supreme, though subject, of course, to the principle that they may be amended by the people acting through the machinery which the constitutions themselves provide. In vital differences between the English unwritten Constitution and the American written constitutions, we must seek for the explanation of certain features of American divergence from English precedents. In result, the general purpose of written constitutions in America has gradually come to be entirely different from the purpose of Magna Carta and the other great constitutional documents of England. In America, to employ Willoughby's careful analysis, written instruments of government and their accompanying bills of rights have, for their aim, the delimitation of the powers of all the departments of government, the legislative as well as the executive and judicial, and it is therefore quite proper to hold that the requirement of due process of law should not only prohibit executive and judicial officers from proceeding against the individual except in conformity with procedural requirements, but also operate to nullify legislative acts which provide for the taking of private property without compensation, or life and liberty without cause, or in general for executive or judicial action against the individual of an arbitrary or clearly unjust and oppressive character. By a long and careful process of judicial construction, the prohibitions of the due process of law clauses have thus come to be applied to all three departments of the state and federal governments, the legislative no less than the executive and judicial. The Supreme Court of the United States, in the leading case of Hurtado versus California, decided in 1884, emphasizes the fundamental distinction between the constitutional doctrines of England and of America, and shows that the provision of Magna Carta has been incorporated into American constitutional law, but incorporated in a way which brings it into harmony with American notions, not only of the supremacy of the written Constitution and of the coordination of the three departments of government under that Constitution, but of the great power entrusted to the courts of declaring legislative acts which conflict with the Constitution null and void. In this case, the courts say, the concessions of Magna Carta were wrung from the king as guarantees against the oppressions and usurpations of his prerogative. It did not enter into the minds of the barons to provide security against their own body, or in favor of the commons, by limiting the power of Parliament, so that bills of attainder, ex post facto laws, laws declaring forfeitures of estates, and other arbitrary acts of legislation which occur so frequently in English history, were never regarded as inconsistent with the law of the land. For notwithstanding what was attributed to Lord Coke in Bonham's case, the omnipotence of Parliament over the common law was absolute, even against common right and reason. The actual and practical security for English liberty against legislative tyranny was the power of a free public opinion, represented by the Commons. In this country, written constitutions were deemed essential to protect the rights and liberties of the people against the encroachments of power delegated to their governments, and the provisions of Magna Carta were incorporated into bills of rights. They were limitations upon all the powers of government, legislative as well as executive and judicial. Applied in England only as guards against executive usurpation and tyranny, here they have become bulwarks also against arbitrary legislation. But in that application, as it would be incongruous to measure and restrict them to the ancient customary English law, they must be held to guarantee not particular forms of procedure, but the very substance of individual rights of life, liberty, and property. Part 4. The history of Magna Carta in America has a meaning far deeper than the influence of a single constitutional document. For Magna Carta typifies those ideals of law and government which have spread to America and to many other political communities that lie beyond the 4 seas encircling the island realm itself. The worldwide diffusion of those ideals of liberty and justice deserves to be studied in its entirety, as a vast historical process which had its beginnings far back in the Middle Ages, and which has shaped and is still shaping in modern times the institutions of all the political commonwealths that owe their spiritual inheritance to England. The history of the Charter's influence upon American constitutional development, as one phase of that vaster process, should be illuminating alike to subjects of the Crown and citizens of the Republic. Above all, it teaches them that English political and legal ideals lie at the basis of much that is best in American institutions. Those ideals, jealously preserved and guarded by Americans throughout their whole history, still form the vital force in political thought and activity within the Union. As the Americans adapt their institutions to the ever-changing conditions of national and international life, those ideals of liberty and justice, founded upon the Great Charter, will continue to inspire and guide them. The Charter has a future as well as a past in the American Commonwealth, for its spirit is inherent in the aspirations of the race. End of section 13.
Section 14 of Magna Carta Commemoration Essays. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by MaryAnn Spiegel. Magna Carta and Spanish Medieval Jurisprudence by Professor Rafael Altamira. Translated by F. A. Kirkpatrick. To a historian of Spanish constitutional law, Magna Carta may offer two fundamental and extremely interesting questions. One is concerned with the analogy between the rights, political and civil, which are defined in Magna Carta, and rights of the same kind which are formulated in contemporary or earlier Spanish legislation. The two pictures may be compared as the results of a process common to all the nations of Europe in the Middle Ages, results produced in two distinct communities which were making their way towards the same end. The other question has to do with the possibility that certain liberties and customs belonging to Spain and the adjoining lands may have had some influence in the formation of the programme which was imposed upon King John by the English barons. This second question has been raised by an English writer, Mr. Wentworth Webster, in his essay on The Influence of the Pyrenaic Fueros upon the British Constitution. Mr. Webster believed that such an influence may have been brought to bear through Simon de Montfort, who, during his government of Gascony, not only saw, in actual political working, many of the privileges recognized by Magna Carta, but was also himself obliged to use them and prove their efficacy. It is natural that the continual observation of institutions, tried and proved by use, should impress one closely concerned therein, should guide the direction of his thoughts, and lead him to introduce these institutions into another country when occasion should arise. Thus the suggestion concerning de Montfort is probable enough, although it would still remain to be proved that, in English constitutional experiments, the particular views of Simon de Montfort were actually predominant in guiding the thoughts of the other barons who had not shared his suggestive experiences. In the case of Magna Carta, it is permissible to examine the question concerning the influence of the Pyrenaic Fueros upon that document, through the agency of such men of that generation as might be acquainted with them. Long before Webster, the Spanish historians, Señores Marie-Heller and Manrique, put forward the hypothesis of such an influence, though not the agency of a particular person, but through possible knowledge of Spanish 12th century legislative documents on the part of the English barons. But they did not support this supposition by any historical proof that Spanish precedents were used by those who drew up Magna Carta. But in fact this question, interesting though it be, depends upon the first question stated above. For it is necessary to know exactly whether there is a true analogy between the two sets of liberties and privileges in favor of certain groups of the population and in limitation of royal power. In proportion as the analogy proves stronger or weaker, the case becomes stronger or weaker for the possibility of the supposed Spanish influence. Or the solution may be simply a resemblance in the results of two independent movements directed towards the same object. This investigation will naturally examine several historical problems which form part of the general question. These problems may be thus stated. 1. Analogy in respect of the number and amplitude of the rights granted in each case. 2. Analogy in respect of their social scope, that is to say, the classes or groups to which they extended. 3. Their chronological relation. The analysis of these 3 points should be completed by comparative study of the two movements, which in England and in Spain led to the results under examination, or at least a study of their chief features and particularly the main point of Magna Carta, namely the limitation of the absolute power of the monarchy and the safeguard of the rights and privileges, not always just, it must be admitted, of the people. Such would be the plan of a complete study of the proposed thesis, but the limits of this chapter admit only of a brief summary of each point. Magna Carta contains some points which specially concern the political situation of England, points which have no parallel in Spain. A priori, this was to be expected. Feudal organization was not alike in the two countries, even if the most feudal regions of Spain be considered. Social elements were not alike, nor the relations between classes. In England there were also certain circumstances purely connected with the person of King John, abuses committed by that particular king which had to be abolished or restricted in the charter. We shall not touch on these points, since there is nothing corresponding to them in Spanish jurisprudence, and we shall only examine those matters which are in their essence common to both countries. Here also, Signors Maryhaler and Manrique have shown the way. They examined one by one most of the chapters of Magna Carta, in order to prove, by comparison with Castilian precedents, and especially with the dispositions laid down in the Corte of Leon in 1188, the priority and in some matters the greater amplitude of Spanish jurisprudence in the points of highest political and civil importance. The observations of Maryhaler and Manrique, being merely a kind of digression in their book, are brief and also suffer from the deficiency of concrete studies, from which Spanish constitutional history suffered at that time, 1862, in most of the topics which it embraced. Moreover, their whole work is marred by a want of organic perception. Nevertheless, most of their comparisons are accurate in the main. To avoid repetition, these comparisons have been summarized here. The two authors prove the priority of Leonese and Castilian jurisprudence, in part also of Visigothic jurisprudence, as defined in the Liber Judicaorum, which during the age of the Reconquest was still in force in Spain, in respect of the rights of widows, Magna Carta, Chapter 8, the establishment of a royal tribunal in a fixed place, Chapter 17, the provisions concerning judicial process, Chapter 39, the judgment of peers, Chapter 21, the vote of subsidies demanded by the king, Chapter 12, and other provisions. These also indicate certain rights which are set forth in the record of the Corte of Leon of 1188 and of other earlier Cortes, and which are not mentioned at all in Magna Carta. For example, the right of declaring war and making peace, and the inviolability of the home. On the other hand, they recognize that Magna Carta contains some provisions, namely the right of trade and of ingress into the kingdom and egress therefrom, which have no parallel in mediaeval Spain. But the observations of Maryhaler and Manrique do not embrace all the points of similarity between Magna Carta and Spanish jurisprudence, nor do they touch the principal topic. For the chief topic, in my opinion, is the general system of limitations imposed upon the Crown. On the other hand, some of the points mentioned by these authors require further study, which should take into account both the whole body of provisions concerning those points, and also the differences of circumstances surrounding these questions in England and in Spain. Thus, with regard to the provisions concerning administration of justice, chapters 17, 24, 40, and 45, in order to comprehend the true relation between English and Spanish jurisprudence in the 13th century, it would be necessary to treat separately some details which form part of the general subject. Thus, two jurisdictions expressly mentioned in Magna Carta, that of the king and that of the barons, should be compared with three jurisdictions existing in Spain, that of the king, that of the consejos, or municipalities, these two working side by side in a relation not yet thoroughly elucidated, and that of the feudal lords, which last had shrunk very much in Castile and Leon in the 13th century. Again, the establishment in England of a fixed or stationary Court of Common Pleas, and the exclusion of pleas of the Crown from the local courts should be compared with the special cases of royal jurisdiction in Leon and Castile, the royal power of calling up cases from inferior courts, and the double process, clearly marked in Spain from early medieval times, of absorption by the King's Court, of seigneurial jurisdiction on the one hand, and the penetration of royal authority into municipal jurisdiction on the other hand. In Spain, municipal jurisdiction, which was gradually won also by the inhabitants of places subject to feudal lords, subjected to the fuero, or local custom, all men of whatsoever social condition, even nobles and ecclesiastics, within the limits of the municipality. This institution, a knowledge of which is necessary to a clear perception of the scope of our jurisprudence, carries the question into a region unknown to English jurisprudence, at the beginning of the 13th century. The provisions established by Magna Carta concerning municipalities already existed in Spain, and the existence of municipal jurisdiction in that country represents a distinct element of extraordinary importance. The subject of guarantees concerning legal process, 39, has two parts. First, prohibition to arrest, condemn, etc., any free man contrary to the law of the land. Secondly, the judgment of peers. As to the first, the Cortes of 1188 established some provisions either identical with those contained in the text of Magna Carta or else resembling them, besides others which are not mentioned in Magna Carta. But the main point, namely freedom from arrest except by competent authority, and freedom from condemnation except according to law and after trial, must be sought in the texts of our municipal fueros, and in statements to be found passum in ordinances of a more general character. With regard to the promise in Chapter 40, which so scandalizes Marie Haler and Mamercay, who exclaim, "In none of our codes or ancient documents do we find the shameful declaration nulli vendemus," it should be said that the same abuses are implicitly indicated in Articles 19, 20, 21, and 29 of the Ordinance of Lyons. The malpractices of administrators of justice in those times were very frequent in all countries. Monarchs continually strove to check these abuses, and Spanish jurisprudence, both before and after 1215, contains very many provisions of this kind. But apart from the matters studied by Mary Haler and Manrique, matters which, as we see, demand further investigation, there are other points of relation between English practice and the jurisprudence of the various Spanish estates. Webster observed particularly the intervention of the popular element and the form of election favored by de Montfort. As to the first point, 2 chapters of the Charter demand our attention. The 13th, which affirms municipal liberties, and the 14th, which deals with the composition and functions of the Concilium Regni. As to both these points, Spain was far ahead of England. Independent municipalities were numerous in Asturias, Leon, Galicia, Castile, Aragon, Catalonia, and also Navarra at the beginning of the 13th century, whereas London was not a municipality till 1189, and in several of these countries the towns constituted a considerable political and social force. Their fueros were confirmed by every king, and the royal oath in the Cortes embraced the whole body of these fueros, and of the privileges possessed by every class. It seems needless to dwell on this point, since it is recognized by all historians. For the same reason it is not necessary to trace in detail the priority and the greater amplitude of Spanish municipal rights, by examining the true significance of the second part of Chapter 13, Praeterea volumus et concedimus, and the scope of the liberties of London at that time. As to the composition of the Royal Council, Spain, that is to say Leon and Castile, shows a distinct advance as compared with England. Our Royal Council, Consejo Real, was already in the 13th century an organism, precarious indeed and irregular in its functions, yet sufficiently developed and possessing a far wider competence than the baronial system to which the Council seems to be reduced in Magna Carta. The Castilian Council included not only the nobles, whose right to be summoned in England is confirmed and defined for the first time by Magna Carta, but also representatives of boroughs and cities, that is to say, a plebeian element, which in the English system had no part whatever in such functions. Their inclusion in the Castilian Council possibly dates from the reign of Alfonso VIII, 1158 to 1214. Moreover, the chief kingdoms of Spain possessed, before 1215, another organism of much greater political and representative significance than the Council, namely the Cortes, which everywhere included representatives of the various classes of the community. The Cortes of Leon came into being in 1188, and the Cortes of Aragon probably in 1163. Catalonia had Cortes a little later, in 1218. In Castile, 1250 is the latest date assigned to their origin. Nor should it be forgotten that, before the introduction of the popular element, the Assembly, Concilium, which aided the king in legislative functions, was in normal and frequent action from the early ages of the Reconquest. This Concilium possessed not indeed the power to pass laws, but the right to propose laws, like the councils of the Visigothic period. The decisive intervention of the Cortes in voting taxation, in which matter they held distinct authority, constitutes, in those Spanish countries which possessed Cortes before 1215, a superiority over the limited guarantees provided upon this point in Chapter 12 of Magna Carta. Chapters 28, 29, and 30 find their equivalent in our municipal and general laws concerning protection of private property. There are numerous provisions which check the abuses committed in seizing goods by way of penal or legal process, protect from seizure the instruments of labor and both the objects and the quantities to be assigned to the yentar y conducho, or feeding and lodging of the king and his suite and of certain other officials. Since these points of our mediaeval jurisprudence have not yet been specially elucidated, it is impossible to get a clear and succinct view of all these details scattered through many constitutional documents. But the complete and organic expression which was soon afterwards given to these points in the Partidas, 1265, in the Leyes de los Adelantados, and in other legal texts of Alfonso X's time, which in great part form a collection of earlier jurisprudence, proved the development which these matters had previously reached. Finally, to avoid a too lengthy comparison between the chapters of Magna Carta and Spanish jurisprudence, I will indicate the provisions concerning the Jews. Chapters 10 and 11 contain nothing favorable to them, rather they aim at protecting widows and minors against Jewish usury. Manifestly, the legal position of the Jews in England was inferior to that which they enjoyed at that time in Spain, and particularly in Castile. It may be said that the period from the 11th century to the middle of the 13th is the golden age of the Jews in Spain. It is true that social opposition to them takes distinct form towards the end of the 12th century, but persecution started much later, and even then royal protection was not wanting to them. The petitions of the Cortes against their usury throughout this period curiously resemble these two chapters of Magna Carta. The limited scope of most of the declarations of Magna Carta must be remembered throughout. The provisions of the Charter do not extend to all Englishmen, but, in most of the chapters, to the nobles only. Those of inferior status have little share in these advantages or, to be more accurate, in the limitations imposed on the royal power. The Charter, even when it does mention villeins, frees them only from some obligations toward the king, not from obligation towards the lords, to whom villeins continue to be like chattels. The status which was obtained by the citizens of London cannot be compared with that which was obtained by the barons. Even if we should accept the democratic interpretation of Chapter 60, there still remain many other chapters in which the royal concessions lie out of reach of the mass of the people. In Spain, on the other hand, and chiefly in Leon and Castile, even the servile classes of earlier ages had attained a great improvement of condition in 1215, and the liberties which were gradually being won chiefly benefited the people in general, not an oligarchy of nobles. Even in Aragon, where later times were to bring retrograde movement in respect of some inferior classes, the advantages actually attained were more widely diffused than in England, and we find the position of the lower classes better protected by a legislation in which they were regarded as important factors. 2. Let us now pass to the most important point of comparison between Magna Carta and Spanish jurisprudence in the 13th century, the point which most clearly marks the tendency of political evolution in Europe and which, for that reason, produced most results in the direction of constitutional control. That point is the attitude of the barons toward the despotism of John Lackland and the guarantees with which they surrounded the concessions obtained, lest the king should evade those concessions. In fact, the whole scheme of declarations and promises contained in Magna Carta is valueless apart from security for their accomplishment. Many Spanish kings made identical or similar promises, and the same thing occurred in other European countries which were passing through the same movement. But the real practical problem does not lie in declarations on the part of one section of the community, or of several sections, or of the whole people, whether represented in Cortes or not, that they propose to limit and censure the king's exercise of authority. The point is the possession of power to accomplish that object. One method of doing this was to bind the king with a series of guarantees constituting for him a danger or considerable difficulty in the ordinary working of his authority and his administration. In Spain, from the Visigothic period onwards, efforts are clearly visible to check the natural propensity of kings towards abuse of power, a propensity which is found in all authority. But the means chosen are either merely moral definitions, such as maxims declaring the king to be the first subject of the laws, or else legal declarations of guarantees which rest solely on the monarch's good faith, such as limitations of the confiscation of private property. The sole effective counterpoise lies in the king's perpetual apprehension about breaking his formal and legal undertakings, in view of the powerful forces concerned in their enforcement. At a later time, the Cortes constitute a systemized guarantee by means of which the people hold the king in subjection through the power of refusing what the king may require, that is to say, supplies. But in all other respects, equilibrium, which is seldom rarely secured, is produced or attempted through the free play of the two counterbalancing forces. And this is why in Castile the power of the municipalities and the whole body of privileges represented by the municipal fueros are so valuable, while in Aragon the social weight of the nobility possesses a similar value. Magna Carta treats the question in quite another manner. The creation of the Committee of 25 Barons, Chapter 61, as a kind of tribunal to judge infringements of privilege, and the functions assigned to this committee in Chapters 52 and 55, as well as the recognition of the right of insurrection in case of breach of faith on the king's part, constitute guarantees which already assume an almost constitutional form. Both these provisions are known to Spanish jurisprudence, but they only attain a similar constitutional force considerably later than the date of Magna Carta. The first device, that of the Committee of Barons, as a tribunal to watch over the fulfillment of the peace and liberties granted and confirmed in the Charter, in Aragon takes the form of the Justica Mayor, insofar as that dignitary, forced upon the king by the nobles, becomes mediating judge or judge of contrafuero, that is to say, examiner of infringements of law committed by the king or his officials. This guarantee was initiated in the Cortes of Eguía in 1265. Its complete development is found in the Privilegio General, won from Pedro III in 1283, and is still more marked in the Privilegio de la Unión, 1287, which forbade the king to take proceedings against any adherent of the Union, whether nobleman or municipality, without the intervention of a judicial sentence by the Justicia and the consent of the Cortes. Something in the same direction, but less effective, is to be found in the privilege of the Aragonese and also the Catalonian Cortes, that examination should first be made of any grievances against the king. In Castile there was nothing resembling the Committee of 25 Barons before the Pacto, of the Hermandad of the nobles and municipalities, Consejos, of Castile, Leon, and Galicia, with the Infante Don Sancho, son of Alfonso X, 1282. This pact established the right of the Hermandad to judge the royal officials and even the judges themselves, and to inflict upon them punishments, including the penalty of death. This privilege or means of security against the king and his officials finds its culmination in the Concordia de Medina, which was forced upon Henry IV in 1463, but this later agreement was short-lived. The second device, that of insurrection, is more fully represented in Castile. The earliest document which we know concerning this is the above-mentioned Pact of 1282, which assigns to the towns the right of insurrection against royal infringements of the law. The same thing occurs in what may be called political programs of other Hermandades of the 13th century, such as the Hermandades which united the towns of Castile, Leon, and Galicia in 1295, and which were confirmed by Ferdinand IV. A similar provision is found in the above-mentioned Concordia de Medina, which establishes the right of making war on the king without incurring penalty, in case the king should proceed against the nobles or ecclesiastics in any other form than that formulated in that document. It would be out of place here to discuss the doctrinal development of this right of insurrection in the hands of theologians and political theorists of the 16th and 17th centuries. This important topic has given rise to an abundant critical literature in recent times. In Aragon, assertions of the right of insurrection were at least as definite as in Castile and had wider results in the sequence of political events. The Privilegio de la Unión declared that, in case the king infringed its provisions, the leagued nobles and municipalities were free to refuse him obedience and choose another sovereign without being guilty of treason. Notwithstanding the astute government of James II, this privilege was ratified in 1347, when the new king, Pedro IV, was obliged to recognize the power, claimed by the Union, of disposing, banishing, and depriving the king if he should inflict punishment without the judicial sentence of the Justicia and the advice of the ricos hombres. But this privilegio was not valid for long in Aragon, since Pedro IV himself annulled it in 1348. To conclude, it is interesting to compare the very wide character of these securities, that of insurrection and that of a tribunal or judge to examine royal infringements of law, in most of the Castilian and Aragonese documents concerning them, with the very special and limited character which they bear in Magna Carta. The competence of the tribunal of 25 barons and the right of insurrection refer explicitly to the peace and liberties granted and defined in Magna Carta, whereas similar securities embodied in contemporary or slightly later Spanish jurisprudence embrace every possible case of infringement of privilege on the part of the king or his officials, although these documents sometimes particularly mention irregularities of legal procedure. The greater amplitude which in Spain from the beginning marks the guarantees won by nobles and by the people may arise either from a natural propensity of the Spanish mind to generalize without giving much importance to the generalization, or else from a complete view of the problem and a desire to solve it entirely once for all. Whichever be the explanation, it is a characteristic trait of our history. Another characteristic is the constant mixture of noble and of popular elements in these acts of resistance to royal despotism and to arbitrary administration. The joint action of both classes signifies that in Spain the liberties obtained had a very wide social reach, especially in Castile, where popular action had a large share in the movement. But it should not be forgotten that in many cases, especially in Aragon, but also in Castile during the reign of Henry IV, the pressure put upon the king had an oligarchical character, a condition of things which is in fact not less dangerous than royal despotism to public rights. The conflict arises not always between a despot and a people suffering under his despotism, but sometimes between a despot and other despots who resist a check upon their despotism. That is to say, class privileges are asserted against the authority of one man's will, and this fact should be well weighed, as it has been weighed by modern writers on Magna Carta, in order not to attribute to political development a much more democratic tendency than it really possessed. What did happen was that those who strove to limit the royal will in their own interests were unwittingly furthering constitutional progress on behalf of all. For they were preparing both the minds of men and the machinery of government in such a way that, when the royal power, representing the unity of the state, should rise above the diversity of aristocratic and local authorities, this single power should not be in a position to injure the fundamental rights of the subject. The dates at which this point was reached and the roads which led to its attainment have varied in all the countries of Europe. Every country has also differed from its neighbors in the vicissitudes of advance and retrogression. In England, apart from some episodes of fluctuating movement, the tendency of national liberties becomes continually more marked from 1215, and soon takes a decisive and progressive direction. In Spain, notwithstanding her priority in this kind of political activity, privileges are lost without any compensating gain to the common rights of subjects, for the absolute power of the king dominates all privileges and destroys that which had been attained in the Middle Ages. Nor is the loss replaced by any analogous guarantees of equal extent. The process is interrupted and is renewed long afterwards, in the 19th century, without the attainment of positive advantages until near the end of that century. But the true history of absolute power in Spain, in order to elucidate how far it penetrated civil and political jurisprudence, still remains to be studied, and any generalization would be, at the present time, premature. End of section 14. Section 15 of Magna Carta Commemoration Essays. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by MaryAnn. Financial Records of the Reign of King John by Hilary Jenkinson, F.S.A. The most superficial study makes it clear that finance played a part of extreme importance in the reign of King John. It is probably not too much to say, considering any of the great crises of his time, that had he commanded even adequate financial resources, the other elements in the situation, the personal character of himself and those with whom he came in contact at home and abroad, political influences, national movements, would have worked out to a quite different end. His period, too, after long neglect, has in recent years received considerable attention. It is strange, therefore, that the existing records which may be either directly ascribed to, or obviously associated with, his financial administration have been to a great extent left aside by historians. It is true that the primary executive instrument of his time was the Chancery, and that Chancery records have nearly all been published for his reign, with introductions which, in some cases at least, still stand. But even the Chancery records are comparatively unworked for the financial points, at any rate for the smaller ones, which they contain, partly, no doubt, because it is the great lack of all the earlier record publications they have no subject index. The direct records of Exchequer administration have, with 2 exceptions, been left severely alone. Here again there is an obvious reason in an obvious difficulty. The Pipe Rolls, the chief, though not the only, class of direct Exchequer records for this reign, being so bulky that inquirers have doubtless despaired of making a just use of them. It would be well if these records could be dealt with in print. Meanwhile, the present anniversary seems to offer an opportunity for the survey of such Exchequer records of King John as remain to us. Having surveyed, we may also do good work by endeavouring to place them. We have a good general summary of Exchequer procedure as it was in the 12th century, in the Dialogus de Saccario, and we know, in outline at least, what the machinery of it was in the period which first gives us fairly complete manuscript remains of the various departments of Exchequer administration, say the early 14th century. It is obvious that the second of these states has grown out of the first, but obvious also that we cannot, without investigation, put down to mere expansion all the changes which we find. There might well have been some violent innovation. Now where do John's Exchequer records stand in relation to this expansion and, if they took place, to these innovations? The fact that the Chancery rolls begin with his reign makes it peculiarly desirable to establish at this point some limit between the 12th and 14th centuries in the matter also of the Exchequer. Even so, we have not exhausted the list of what may properly be considered preliminaries essential to the study by historians of John's finances. All administrations, perhaps everywhere, certainly in England, have been from the earliest date subject to the mysterious influence of the legal fiction. Old forms, that is to say, because they were established and because they had legal sanction, have been adapted to violently new uses. 2 people play at going to law in order to transfer land with the greater security. The king makes out a receipt for money he has not received from A, in order to have a convenient substitute for cash with which himself to pay B. We have in fact to consider the records of, for example, the annual audit in the light of transactions which we know from other sources to have taken place, in order to settle the question whether the Pipe Roll at a given period represents what we should expect it to represent, a survey of the year's income, or whether it is only partially this, or not this at all. Reversing the process, we have to test, where possible, our knowledge of the alleged exaction of the king by its representation in records. Does the statement that the king imposed a talliage of 20,000 marks mean that he obtained 20,000 marks? In the vast majority of cases, administrative documents and narrative descriptions have not both survived for any given transaction in early medieval times. But an examination of the cases where they have will furnish a criterion of value for the large number of cases where only one or the other remains to us. To deal with such problems as this is obviously beyond the scope of a single paper. Indeed, for the most part, they must be left till greater facilities in the way of printed and indexed records are available. At the same time, in view of the wide and unquestioning use which has been made of chronicle statements, the point is worth raising. Meanwhile, we may attempt perhaps with some profit the survey of the wealth which remains to us, and to a certain extent the classification of the records from the point of view of the part they played in the administration of the various departments. For the purposes of a survey it will be convenient to travel backwards. Briefly then to summarize what is well known, the financial documents which remain to us from the time when the course of the Exchequer was well established, say at the end of the first quarter of the 14th century, are as follows. It may be premised that we are attempting only to deal with those officials who left us records, i.e., direct records of the particular processes they controlled. For example, we are to display an interest in the chamberlains of the receipt, but not in the tellers, important as the latter ultimately became. To begin with the Exchequer of Audit. This is represented by the two departments of the King's Remembrancer and the Lord Treasurer's Remembrancer. The latter's department is that of final audit, represented in records by the Pipe Roll and the divisions which split off from it. The King's Remembrancer's department, that of preliminary audit, is represented in records by a mass of vouchers of every shade of variety in point of officiality, provenance, and writing, and by some preliminary statements or summaries of accounts, compotuses, compiled from the vouchers. These last are closely connected with the enrolled accounts mentioned above. All these are an origin part of the Ancient Miscellanea of the Exchequer, K.R., and are represented now by a number of classes, principally those known collectively as Exchequer accounts. The supplementary, interim, or domestic affairs of the Upper Exchequer as a whole, the proceedings of the barons, their minutes and correspondence, are represented in the case of both these remembrancers by a memoranda roll in which each of them had noted such of the proceedings as interested his department. In many cases the same information would appear in both rolls. These memoranda are, of course, the distinctive records of remembrancers. At the time we are speaking of they are arrayed in definite divisions, including the Adventus Vice Comitium and Dies Datae, showing the arrangements made for audit, the Brevia Directa Baronibus, a section of in-letters, the Status et Vicis Compotorum, the Brevia Retornabilia and Irretornabilia, out-letters, the Precepta, instructions for issue of writs of process, and a section in which private deeds are enrolled, and, most important of all, the very lengthy Communia, with various subsections, the chief of which is that of the Recorda of revenue cases, which come up for decision before the barons. This last section is intimately connected with the origin of the separate Exchequer of Pleas, but precisely how intimately has not yet been settled. Behind or below this Exchequer of Audit, separate from but subject to it, is the Department of Receipt, represented qua officials by the Treasurer and the two Chamberlains or their deputies. Speaking broadly, the duties of these three at the Recepta are the same, and they are represented in records by either a common collection or a triplicate series. They record the operation of receipt by preserving counterfoils of receipts, the foils of tallies or contre-tally, and eventually the stocks of the same when these come in after audit, and copies of the inscriptions of these tallies on rolls, receipt rolls, the operation of issue by preserving the original writs for issue, copies of these liberate rolls or notes of them, issue rolls. Besides the Recepta, there is another office where receipt and issue go on. When the differentiation of the Exchequer from the Curia was complete, the result was the elimination of any personal control by the monarch. The same thing occurred in the departmentalization of the Chancellor, who, with his staff, controlled the Great Seal. In each case the result was the same. Under the older official, or rather body of officials, there grew up an official or an office closely resembling it in functions and to some extent in methods, but controlled, as itself had originally been, directly by the sovereign. At its weakest the new body acted as a link between the older one and the king. At its strongest it usurped in his behalf the authority of its prototype. The departmentalization of the Curia, in fact, brought into existence the Camera. The household grew up as an administrative organ beneath the court. Thus below the process of the Great Seal, preliminary or subsidiary to it, we have that of the Privy Seal, and presently below this, in its turn, the Signet. Similarly below the Exchequer, upper and lower, auditing body and receipt, we have financial functionaries of a less official character. Notably we have, well established long before the 14th century, the Wardrobe, taking upon itself to a greater or less extent, according to the relative strength of the king and ministers for the time being, the function of receiving and, more particularly, of spending the king's money. Of the activities of the officials of the Wardrobe, record is preserved to us in the shape of a regular series of accounts, with quantities of attendant vouchers, among the records of the king's remembrancer. Apart from the direct operations thus recorded at the two departments of the Upper Exchequer, at the Receipt, and at the Wardrobe, record is preserved at the Chancery of the part played by that executive in originating active financial operations. Writs for issues and those concerned with the audit process, writs of account, allowance, pardon, etc., are preserved in copies made as they issue from the Chancery. We have in particular the Chancery Liberate rolls, because these many other letters under the Great Seal must necessarily concern the Exchequer either directly by causing payments in or out, or indirectly by modifying the property in respect of which audit takes place. As these letters, unlike the writs mentioned above, are not directed to Exchequer officials, copies or notes of them extracted from the Chancery enrolments must be sent over to the Exchequer, where they are preserved in the shape of originalia, or Chancery estreats. Finally, we must give a word in passing to another class of non-Exchequer records, the rolls of the Justices, full of subjects so interesting to the Exchequer as amercements. As these were preserved at the Treasury of the Exchequer, they were presumably available there for reference. But estreats were also prepared from them, whether by the Justices or the Exchequer officials, for the information of the Exchequer and its accounting officers. It is to be noted that all the operations which lie at the base of the classes of documents we have touched on are simple ones, which, in a primitive form at least, are going on in the earliest times at which we have detail of the organized finance of the King's courts. To return now to these earliest times. In the time of the Dialogus, we have an Upper Exchequer represented in records by the Pipe Roll, the form of which, a fact confirmed by existing rolls, is essentially the same as that we find later. It is written, we are told, by the Treasurer's scribe from his dictation at the actual time of audit, and at the same time a copy was taken by the Chancellor's scribe for the Chancellor. We may add for completeness a reference to the existing rolls and their publications by the Pipe Roll Society. There is evidence of the production of original writs of pardon or allowance at audit time by the accountant, and of their preservation by the Marshal. At the Recepta the officials are the same as we find there later. The tallies given out as acknowledgments of sums paid in are also practically the same, and the foils, and subsequently the stocks, are preserved in like manner. The writing on them is done by the Treasurer's clerk. The same official also deputat scripto the sums received. Possibly this is a reference to the rotulo receptarum, which is also mentioned. Payment out is already dependent on a writ of liberate from the Chancery, which the officials of the Receipt preserve after it has been honoured. Two examples of the Henry II period have survived. Before going any further, we may interpolate here some remarks about the separate financial administration of Normandy, an administration which, of course, was not in existence, so far as concerns this country, at the later date we have been discussing. Stapleton, who edited the rolls of this Norman Exchequer for the Society of Antiquaries, quoting allusions made in the Dialogus to this Scicarium Transmarinum, discredits the suggestion that the English system was based on the Norman, a position taken also by most modern writers, but makes it clear that there was a separate Norman Thesaurus in 1131, and the balance of opinion seems to be in favour of accepting the fact of a Scicarium in session in Normandy as early as 1171. It is to be noted that the Dialogus expressly describes this overseas exchequer as essentially different from the English one, and Professor Powicke in describing its functions is, of course, noting some functions and fashions which are certainly not English. The surviving rolls go back to 1184. It is further to be noted that in the time of the Dialogus we have already allusions to financial transactions carried on by some machinery other than that of the Scicarium and Recepta, by the Camera, in fact, both in England and in Normandy. In the Chancery, it appears from the Dialogus, the Chancellor's clerk keeps a rescriptum, otherwise called contra brevia, of the writs of liberate, pardon, and allowance issued, and these contra brevia may apparently be produced at the Exchequer Board of Audit, just as the contralotti are produced for checking purposes by the officials of the Receipt. Turning to judicial records, we find that the Dialogus supplies no evidence of the existence of plea rolls in its time. The earliest which have survived are of the reign of Richard I. But it is clear that information concerning amercements imposed is furnished by the justices. Now it will be noticed, as one compares the 12th with the 14th century, that we have here certain large gaps. At the receipt we have seen nothing of any issue or liberate roll. In the chancery there is no preparation of originalia, though the rescriptum or contra brevia seem to be used for the same purpose. Finally, we have said nothing, so far, in relation to the 12th century, of the remembrancers and of their most distinctive records, the memoranda. I have mentioned these last because we have here a matter which needs rather more detailed discussion. It is clear, of course, that in the time of the Dialogus the business of audit was not divided up into the preliminary and final department of the King's Remembrancer and the Lord Treasurer's Remembrancer, or any two officials under other names. But that does not mean necessarily that there were not at that date remembrancers, or at any rate some officials whose successors ultimately became remembrancers. Moreover, we have yet to mention two more officers whom the Dialogus does chronicle, with their records, Master Thomas Brown and the Archdeacon of Poitou, Richard of Ilchester, for a short time Seneschal of Normandy. These being two and unplaced in the Exchequer scheme of things, and the later remembrancers, who are not mentioned in the Dialogus, being also two, it is naturally tempting to equate the pairs. Thus Dr. Poole has long been accustomed to see, in Thomas Brown and Richard of Ilchester, the origin of the two remembrancers who first appear by name under Henry III. The position of both at the Exchequer Board is certainly anomalous. Of Thomas Brown we are told that at the court of the Sicilian king, before he came over to that of Henry II, he was in regis secretus penna praesapuus, and that at the English Exchequer he sits in quarto scano quod est oppositum justicario, and that he has a copy made from the pipe roll, or parts of it, at the same time as the Chancellor's clerk makes the Chancellor's counter roll, his own clerk having a special seat given him that he may be able to discharge this duty, that he also has a clerk at the receipt who liberum habet facultatem scribendi, cui recipienter et expendentur. Of the Archdeacon we are told that his clerk kept rescripta of the writs of summons which he used for the purpose of checking them when they were read out at the audit. We are also given details of his place at the board. As to the peculiarity of the position of these two administrators, Thomas Brown's privilege of keeping for his own use a third roll is praetor antiquum consuetudinem, while the Archdeacon's position is ex officio quaedam set ex novella constitutione. In the case of this last passage a variant reading would tell us that he sits non ex officio. The first of the above remarks seems to me to show that Thomas Brown's position was ad hoc, created not for an office which he filled at the moment, but for him. Taking this view, I should be disposed to accept the non in the second passage, though even without it, the remark does not, I think, establish conclusively the officiality of the Archdeacon's position at the board. Ex novella constitutione is elsewhere applied to Thomas Brown, and is there explained as meaning added by the present king. At this point I come, with great diffidence, into conflict with the view which sees in these two the ancestors of the remembrancers, officials, be it noted, who are not known to occur under that name before the reign of Henry III. The identification of the Archdeacon and the Lord Treasurer's remembrancer may here be left. It is a matter largely of taste, for it depends almost entirely upon the interpretation put upon the passage quoted above, though there is possibly some force in the fact that the Archdeacon is connected with the function of summons, together with the fact that if Thomas Brown is the ancestor of the King's remembrancer, there seems really no reason why the Archdeacon should not foreshadow the Lord Treasurer's remembrancer. If Thomas Brown's suggested position be not substantiated, then the similar suggestion for his contemporary rather falls to the ground. Now as to Thomas Brown. Dr. Poole's argument is that the words quoad or portet excipiat applied to his clerk imply a selection of topics, and that the Regni Iura, Regis qui secreta, contained in his roll are very nearly what the later remembrancers wrote in their rolls. In making this point Dr. Poole has to dismiss the statements that any errors made in excipiendo can easily be corrected by a comparison with the Chancellor's and the Pipe Rolls, together with an important comment of Discipulus in this connection. This is difficult, and an even greater difficulty is that the same word excipere is applied to the work done by the Chancellor's clerk, who undoubtedly makes an exact copy from the work done by the Treasurer's clerk. As to the word secreta, Dr. Poole has already explained its use in connection with Thomas Brown's Sicilian experiences as referring to the Duana de Secretis, and there seems to be no difficulty here in explaining it either, as Professor Haskins does, as a piece of mere magniloquence, or as being borrowed by the writer of the Dialogus from his own previous description. The man who was great in the Secreta of Sicily was also great in our English Secreta, a piece of allusiveness quite in character. Of course it may be argued that Brown did keep an exact copy, but that, in spite of this, he was a remembrancer. I confess I find it quite easy to suppose that a restless experimenter, to adopt Professor Haskins' description of Henry II., temporarily included special members in his Court of Exchequer in order to have the advantage of their advice, and in consideration of their financial experience, which was well known. Elsewhere I have tried to show that so early as the beginning of this king's reign new revenue problems were making the conduct of the audit upon the old lines by no means a simple matter. It is much more difficult, I think, to suppose a permanent change to have been made by revolutionary innovation at the Exchequer, whereas, as the Dialogus shows, the ancient course was already a shibboleth. Such changes are extremely rare in the whole of Exchequer history, and indeed in the whole of English administrative history. It is much easier to suppose that the remembrances were merely the evolution into a separate name and recognized office of the simple clerks of one of the original officers of the court, just as was the case with the Chancellor of the Exchequer, originally the Chancellor's clerk, and the Clerk of the Pipe, Treasurer's clerk, at the Upper Exchequer, the Clerk of the Pells, Treasurer's clerk, at the Receipt, and other distinct officials in other courts. This is perhaps again very much a matter of taste, but there are other arguments less open to that objection. The nature of the later memoranda rolls does not suggest that they originated in copies from the Pipe Rolls. They consist, in fact, largely of things which are not in the Pipe Roll. Again, neither of the later remembrancers had any function at the Receipt. Thomas Brown kept a clerk there. Final and strongest argument against this derivation of the remembrancer's office, the Dialogus actually mentions the making of memoranda, and memoranda of such a nature as we should expect. Very little, it says, is written at the Easter Scriptorium. Tamen quaedam memoranda quae frequenter incudunt, sursum tuc scribuntur, ut soluto scacario dihias discernant, maiores quae quidam non facile propter numerosam sui multitudinem nisi scripto commendarenter, occurrerent. The volume of business is so increased that many matters, so many that they must be noted in writing, have to be reserved for discussion, so to speak, out of term. We shall have to return to this later. For the moment the interesting point is that this writing is done a clerico thesauriae. In treating, therefore, this section of records, it is from the view of the memoranda that we must start, that is, from an expectation of finding in the Pipe Roll such a growing unwieldiness and confusion as would necessitate the regular making not of extracts from it, but of notes of preliminary and interim matters which need not ultimately appear in the Pipe Roll at all, and from the parallel expectation of what, when we find them, the first memoranda will be. So we may turn, after a rather long digression, to the actual records of John. End of section 15. Section 16 of Magna Carta Commemoration Essays. This is a LibriVox recording. All LibriVox recordings in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by MaryAnn. Financial Records of the Reign of King John by Henry Jenkinson. Part 2. Pipe rolls. These exist for every year except the 15th and 18th, and fragments of the latter are made up in the roll of the 17th year. Chancellor's rolls exist for the 3rd, 4th, 7th, 10th, 13th, and 17th year. That for the 3rd year was printed by the Record Commission. There is also a fragment in the Exchequer K.R. Miscellanea 1-6. Memoranda. 2 rolls are definitely so called, though they are not now numbered with the classes of that name. They are Exchequer L.T.R. Miscellaneous Rolls 1/3 and 1/4. Vouchers and Miscellanea. Classed as such, though we may have to bestow some of them elsewhere, are at present 1 document in Exchequer K.R. Miscellanea, and 11 among the Exchequer Accounts. Of the latter, 6 are Mise and Imprest Rolls, partly known by the Record Commission publication, Exchequer Accounts 349, numbers 1b, 2 and 3, and 325, numbers 1, 21, and 2, and referred to under Household below. Of the remaining 5, 2, Exchequer Accounts 505, numbers 2 and 3, have to be eliminated at once, as they belong really to the following reign. On the other hand, 1, Exchequer Accounts 349, number 1a, at present classed as belonging to the previous reign, must be assigned to our period. We have therefore to consider under this heading 5 documents, of which 1, Exchequer Account 152, number 1, has been printed by a foreign student. Tallies. 1 possibility of this reign has survived. Receipt rolls. We have 1 doubtful fragment, Receipt Roll 2, and 1 Jewish roll, Receipt Roll 1564. For purposes of illustration, we may note 4 earlier fragments: 2 of Henry II, 1 of Richard I, and 1 a Jewish roll of the same reign. Issue rolls. None survive. Original writs of liberate. 1 such has been found in Ancient Correspondence, volume 47, number 2. Household or Camera. Here are to be classed the 3 Mise rolls and possibly the 3 Prestita already mentioned. 2 of them were formerly included among the Chancery rolls and were printed by Hardy. They came from the Tower, which was a repository both of Chancery and Exchequer records. The remaining 4 probably came from the Record Office, all from the Carlton Ryde repository of the Ancient Miscellanea of the Exchequer K.R. Of these 4, the 2 Mise are duplicates, the best of which Cole has printed. Cole has also printed 1 of the Prestita, but the other has not yet been published. The Mise are of the 12th and 14th years of John, the Prestita of the 7th, 12th, and 14th to 17th years, the last, 14th to 17th, being unprinted and consisting really of separate rolls for several years. It will be noticed that we have made so far no reference to Originalia or to Norman records. Both require some reference to the Chancery as well as the Exchequer, and may therefore conveniently be treated together here. Originalia. Actually at the Exchequer there is no trace of these. The classes of Chancery records from which the Originalia, when they came into existence, were drawn give us in the time of John a varying amount of Exchequer information, and to these we must go direct. We may note them in the Chancery. Liberate rolls. There are 3 of these belonging to the 2nd, 3rd, and 4th years of John. All were printed by the Record Commission, with an introduction by Sir Thomas Hardy, but we shall have a small addition to make to them later. Close rolls. These again were all printed by the Commission with an elaborate introduction, also by Hardy. Including 3 duplicates, they number 15 rolls covering the 6th to the 9th and the 14th to the 18th years of the reign. We may add that 2 fragmentary membranes have been recently discovered and added to the rolls of the 16th and 17th years. These fragments fill a number of gaps in the printed version. Fine or Oblata rolls. Including 3 duplicates, there are 11 of these covering the 1st, 2nd, 3rd, 6th, 7th, 9th, 15th, 17th, and 18th years of John's reign. These, once more, were all printed by the Commission under Hardy's editorship. We shall have later to say a few words with regard to the nature of these Chancery rolls. For the moment we may leave them, adding, in passing, a mention only of the Patent and Charter rolls, less directly connected with Exchequer procedure, together with a note that we shall have ourselves a small fragment to add to the Fine roll class. Turning now to the Norman records, we have to examine two divisions, Exchequer and Chancery. The first of these, that of the Norman Pipe Rolls, includes duplicates, presumably Chancellor's rolls, though they were not known under that name. It consists now of a collection, formed in 1862, of 18 rolls, 14 being of the reign of John and 4 of an earlier date. These rolls were edited in 1840 and 1844 for the Society of Antiquaries by Stapleton. Unfortunately, the later arrangement does not correspond with that of Stapleton, and it is a little difficult to decide which rolls he used. It is clear that he collated the duplicates to some extent, but that he had not access to all of them is plain from the fact that he printed the very fragmentary roll number 22, membrane 16, of which number 6 is a practically uninjured duplicate. It may be convenient to add here as a footnote a key to the rolls used by Stapleton. We have to add the fragment discovered and printed by Delisle, though this does not belong to our period. We shall have later to make a small addition ourselves. We come finally to the Norman rolls of the English Chancery. These form part of a single series, applying in turn to the reigns of John and Henry V. Hardy printed 6 rolls for the first of these reigns, 3 of the second year and 1 each of the third, fourth, and fifth, and 1 for the second, with an introduction which is for once definitely inadequate. He does not consider the question whether a single title is really applicable to the rolls of the 2 reigns, nor, though he gives some faint indication of it, the fact that the rolls of our period are themselves by no means a homogeneous series. His work was continued, for the reign of Henry V, in a calendar in the appendix to the Deputy Keeper's 42nd report, without any recognition of the fact that in the meantime an entirely new Norman roll of John had been added to the series number 1. The rolls are now numbered in an order different from that in which Hardy printed them, and that a new membrane had been added to one of the rolls, number 6, already published. The extra roll need not, in point of fact, trouble us here, as it has in reality nothing to do with Normandy, being a portion of an English Liberate roll. In concluding our summary we must add, for completeness, a reference to the plea rolls of this reign. There are 55 plea rolls of the King's Court and 12 belonging to the class of visitational jurisdictions, also to the early files of feet of fines containing fines of our period, some of which have not been printed. We have thus, unpublished and unconsidered, besides the pipe rolls and all save one of the Chancellor's rolls, 2 memoranda rolls, 5 documents in the class of Exchequer accounts, 2 in that of receipt rolls, 1 and a fragment in that of the Norman rolls, 1 at least in that of the Norman pipe rolls, and 2 fragments in that of close rolls, together with a tally and an original writ of Liberate. The 3 last named need not detain us. We have in addition a body of unpublished plea rolls and feet of fines, the indirect evidence from which might be considerable, but this again is beyond our scope. And we have suggested that the significance of the Chancery rolls published by the Record Commission has by no means been exhausted as yet. In opening some investigation of these possible sources of information, we may conveniently recapitulate 1 or 2 points with regard to Exchequer procedure which it is very desirable to remember. A. Touching the relation of the Upper and Lower Exchequer. 1. Receipts of the King's revenue do not necessarily all appear on the Pipe Roll. I have noticed elsewhere the case of Jewish receipts and the collection of William Cade's debts. Moreover, the whole of the revenue of the Crown does not necessarily go through the Lower Exchequer. We have already mentioned the possibilities of the Camera. 2. In the case of issues, the Pipe Roll is even more incomplete. Essentially, it covers only the cases where an official has money paid him for which he is held to account, these being generally cases in which the money is not paid out of the Treasury at all, but subtracted in advance by the accountant to meet current expenses from that which he will be expected to pay in. It is thus seen that the Pipe Roll is not a guide to receipts and expenditure, and that the only relation between the Upper and Lower Exchequers is that the latter is required to give evidence, not of all of its receipts, but of such only as establish or disprove the statements made by an accountant at his audit. B. As to Norman and English administration. Historians have been agreed up to the present that the Norman Scaccarium is merely a reproduction in Normandy of the English one. mutatis mutandis, made for convenience. Similarly, a Norman thesaurus reproduces the English thesaurus. Since there is no audit of the king's receipts and issues as a whole, an exchequer procedure acts only as a check upon the local accountant. There is no inconvenience in this. Previous writers, however, have taken the existence of a similarity in points of surface procedure between the two rather for granted, in spite of the warning of the dialogues. Delisle, for instance, in a work which still stands so far as regards its survey of the divisions and resources of Normandy as a revenue-producing country, treats the actual machinery of the Scaccarium in somewhat cursory style, boldly applying the dialogus description of the English institution to its Norman parallel, and even importing into the latter without evidence a system of originalia which did not adorn the English exchequer, so far as we know, till a later date. Beyond an inaccurate description of one of Stapleton's rolls as a receipt roll, he has not found it necessary to make any serious attempt, nor have his successors, M. Valine or Professor Powicki, to establish the existence and scope of other records or record processes in Normandy. Nor, though it is agreed that one chief executive office, one chancery, controlled by both countries, have they looked very far for any possible special treatment by the chancery of Norman affairs. We turn now to the pipe rolls of the reign of John. The bulk of these, as has been said, is so enormous that it would be unwise even to attempt to sketch out all the problems which the student of them will be called upon to discuss when they, with those of Richard I, are in print. It must suffice to venture one or two theories as to the lines upon which growth was going on in the class during our period. Growth, that is, away from originally simple essentials into the utter confusion which undoubtedly reigned at the end of the 13th century, and the highly complicated character which, we know, marked these records from the latter part of Edward II's reign onwards. It would be particularly unwise since, apart from the bare outlines just suggested, no one has yet made such research as would enable us to get a clear and detailed idea of the state of things which was in existence in these later periods. Under these reservations, we may venture here to put forward the fairly obvious suggestion that later developments of the originally simple pipe roll hinge entirely on the attempt to apply this essentially simple machinery either to business for which it was not designed, or to business of a bulk so vastly increased that it broke down under the sheer weight. I have suggested that as early as Henry II, the machinery used for getting in, or for assuring, what was then the greater part of the king's income was proving quite inadequate to provide him with cash. That so early as 1166 the king was habitually anticipating many and large sums by means of assignments. This alone introduced cross-references into the accounting to an extent almost unbearable, and it is to be remembered that the use of these convenient assignments was continually growing. Again, the sources of income which figure in our original picture of the Scaccarium all increased in bulk. The cases, for instance, which came into the king's court, and consequently the fines and amercements, alone sufficed by their enlargement to upset machinery based on an idea that all the accounts could be assembled at the annual exchequer in a limited period, their accounts audited, and the roll describing the process written up while that process was going on. Besides, the actual numbers of sources of income increased, and though, as in the case of the Jewish talliages, many of them do not come under the pipe roll audit, yet we may argue, I think, that exchequer opinion would be always working up towards a state of affairs when these new sources should be under the same restrictions as the old. Throughout its long history the exchequer was always trying to subordinate the new, whether in material or forms, to the old. Not only this, but it would be, we know it was, working up always towards the inclusion of the spending departments in the audit. That is to the state we find when foreign rolls and the like modifications appear. Finally, in considering the developments we may expect to find at the exchequer, or indeed in any administrative department, we have always to reckon with the fact that John's reign followed that of Richard, a period which introduced new elements of confusion while it is scarcely likely to have found time for much rearrangement or reform. The early pipe rolls, at least, of John's reign contain references to numerous arrears of the time of his brother. An entertaining instance may be found in the cases of certain people who still owed substantial fines for siding with Count John. Taking all these considerations into account, we may confidently anticipate that the reign of John will find the Exchequer system as it was badly hit at certain definite points. There is a difficulty of getting business through in anything like a reasonable time, a tendency of the audit to spread over a longer and longer period. Convention makes its proceedings begin at Michaelmas, but from Michaelmas they extend for an ever-lengthening time. The resulting confusion, since the sheriff of one county accounts in October while he of another is perhaps not dealt with till March, between the accounts of a given year and those of the preceding and succeeding ones is potentially very great. There is confusion also between different kinds of Exchequer records at any given date. For example, the Yorkshire receipts of March of a given year might belong to the Yorkshire audit of the previous or following year. A pipe roll which shall be written up at the actual time of audit becomes, in fact, an impossibility. Further, there is a legacy of arrears, and these we may say are increasing. Finally, there is a confusion between transactions which go on the pipe roll and those which do not, a confusion that is between treasury or recepta matters on the one hand and camera matters on the other, which may be productive of extreme inconvenience in public administration. From these facts again we may deduce the probability of an attempt to solve Exchequer problems on certain definite lines. First, we may expect to find preliminary and supplementary processes of all kinds going on at the Upper Exchequer before and after audit, all the year round in fact. Secondly, we may deduce a pipe roll made up beforehand and consequently having to be either corrected at audit time or else left blank or incorrect in parts. And again we may expect the beginning possibility of some organized forms of new account, some attempt, it is the obvious remedy for congestion at the final audit, at a preliminary compotus in several chosen cases, and certainly of the habitual accumulation of a great many vouchers and memoranda. This last in particular, the extension of the habit of keeping memoranda, is a fairly certain deduction. The mere lapse of time which may occur between the preliminary interview of the Exchequer officials with an accountant and his final examination, the mere amount of confusion that may be caused in his accounts by the fact that he has paid in money in 2 or 3 different ways and places, these and other considerations, such as we have adumbrated above, must, if anything at all is to be accomplished at the Exchequer, connote some attempt at organized memoranda of extra audit transactions. It is to this class of records, therefore, that we must turn for indications of the new developments in audit procedure which were produced by the time and circumstances of the reign of John. Before we do this, however, we may perhaps glance at the Norman Exchequer. We know that the two Exchequers are at least closely connected, and we know that Richard of Ilchester was transferred to the Norman Exchequer in 1176, presumably in order to effect changes of some kind, whether these were in the direction of differentiation from or approximation to the English model. In the first place, are these Norman pipe rolls so close to the English ones in some surface matters as is assumed by most people and to some extent by Stapleton? The 18 rolls fall into 2 groups. The smaller of these consist only of 3 rolls. One of these occupies 2 pages in Stapleton and is fragmentary. We may say at once that most of the missing part is to be found in the unprinted Exchequer account already referred to, which has hitherto been described as a mise roll and ascribed to the reign of Richard I. The 2 fragments form together an almost complete account of the receipts and expenditure of Warren de Capon, Seneschal of Normandy, in 1200/1. The other 2 rolls are duplicates, and are similar accounts of Robert de Vertelli-Pont, then bailiff of the Roumois, in 1203. The larger of the 2 groups is that of the Norman pipe rolls proper, but they differ from the English ones in several important respects. All are of much the same breadth, 11 inches, but this is not the same as that of their English contemporaries, which are about 15 inches. In length again they vary between 3 and 8 feet, the largest rolls consisting of a number of membranes sewn head to tail, the English rolls practically never exceeded 2. Another point of difference is found in the way in which they are written. Some are indexed at the tail of the membrane, as all the English ones are, and they have place headings, and, after the form, subject headings which correspond mutatis mutandis with those of the English ones. But they impress one rather as having a common tradition with their English contemporaries than as being written by scribes trained in the same school. It is possible that this surface impression is incorrect, but in any case it is not improbable that a paleographical examination of the two sets of rolls might establish points of importance with regard to the relations of their producers. But there is one more noticeable difference to be mentioned. We have already alluded to the inclusion in the Pipe Roll of accounts other than those of the normal accounting officials, as being one of the obvious results which must spring from the widening of the sources of revenue, and as one of the great changes, crystallized in the 14th century, of which earlier traces might be found. The distinction of such from the ordinary accounts which appear on the Pipe Roll are, first, the fact that they may be rendered by all kinds of officials; secondly, the fact that they are more marked by division into receipt and expenditure, each of these being usually given a summa totalis; and finally, the fact that the receipts may represent sums not collected from the King's subjects to be paid into the Exchequer and only expended upon the King's special order, but sums received from the Exchequer expressly for the purpose of definite expenditure. Now the germ of such accounts is to be found in certain early Pipe Rolls and in certain exceptional cases. Thus the warden of a mint must necessarily, from the nature of his business, account in some such way as that just described. Besides this, cases will be found such as that of the Sheriff of Kent, who was charged with military building on a large scale at Dover in 32 Henry II. In that case the sheriff renders account, among other matters, de recepta sua de thesauro. The Norman Pipe Rolls seem undoubtedly to carry this principle further, and it is possible that we see here Richard of Ilchester adopting at the Norman Exchequer reforms which his English experience had shown him to be necessary, but which, for various reasons, were delayed in England till a later date. This may lead us to a discussion of the small second group of 3 Norman Pipe Rolls. These rolls are narrow, 8 or 9 inches, and short. They use the phrases of the Pipe Roll, redet compotum, est quietus, and so forth, but they are also distinguished by new ones, and they are distinguished particularly by a division into 2 main parts, receipts and expenses, with a final balance. Not to linger over the description, they are strikingly similar to the later compotus of the English Exchequer, the preliminary accounts compiled from vouchers in the King's Remembrancers Department, which we noticed above, or to the final copy of these enrolled among the foreign accounts; and they show us first the Seneschal and then Robert de Vitry-Pont expending money received for the purpose from the Exchequer, even from the English thesaurus. We have in fact at the Norman Exchequer an anticipation of 2 most important points in later English Exchequer processes: the auditing of foreign accounts, including a considerable quantity of accounts of expenditure, and the auditing of them apart from the ordinary Pipe Roll process and on a different kind of roll. This is to say that we have found, if our suggestion is correct, an anticipation of the later attempt to meet difficulties of time and place caused by increase in the number and size of accounts, by means of a separate audit. Let us turn now to consider the other expedients which, as we have suggested, must have grown into greatly increased use to meet the same difficulties, the memoranda which, in an embryo form, we saw existing in the time of the Dialogus. End of section 16. Section 17 of Magna Carta Commemoration Essays. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by MaryAnn. Financial Records of the Reign of King John by Hilary Jenkinson, Part 3. In this connection we may examine in some detail the first of the 2 memoranda rolls already noted, though it is to be remarked that neither in this case nor in that of many other records mentioned in this paper can anything approaching exhaustive treatment be attempted. Indeed, the present roll bristles with points of administrative interest which we cannot even notice here. This roll bears on its first membrane the title Communia Memoranda de Termino Sanctus Michaelis post mortem Regis Ricardi anno Regni Regis Johannes Primo. It consists of 16 membranes, all of much the same breadth, about 6 inches, with 6 small pieces of parchment considerably narrower. Membrane 2 is entitled Item Communia Membrana Mich, and membranes 3, 4, Dorsae, 5, Dorsae, and 6 are similarly described. Of these, membrane 1 has the subtitle Isti sunt vice comites, cui vinerunt ad Sicarium in cras Tino, Sancti Michaelis vi prosse miserunt anno regni Johannes I. Membrane 5, D, which is continued by membrane 6, has the subtitle De singulis vice comitibus cui ponunt plura debita super singulos. The meaning of this is made clearer by the form adopted on the next membrane, De vice comitibus cui ponunt debita unus QSQA super alterum, to which a frivolous scribe has added what is possibly the earliest known official jest. The remaining membranes are all of the same kind, each containing matters grouped together under counties. Thus membrane 4 deals with Surrey and Kent, membrane 5 gives us the affairs of Nottingham and Derby, membrane 9D those of Oxford, which are continued on membrane 10, and so forth. Membrane 13 is devoted to Jewish business. The small membranes may be left for the moment. It is clear that we have here rolls similar to the later series of memoranda rolls. The arrangement makes this plain, giving us, as it does, adventus vice comitum on the first membrane, and so considerable an amount of the well-known later division of communia. It is fairly clear also that we have not here the first of the series. It is not sufficiently experimental, and indeed there are definite references to earlier memoranda. But to consider the communia in a rather more detail. A large number of the entries under this heading consist of dies datae, days assigned to accountants for their auditing, or respites or adjournments. There are about 60 such entries, and roughly speaking, they follow a chronological sequence, though to make this nearly perfect, we must suppose that membrane 4D should properly follow membrane 2. Thus, starting with adjournments which are mostly for October or November, we work down to those for April. Interspersed with these entries, we have about a dozen cases where it is definitely mentioned that so-and-so venit hic, or venit coram baronibus, on a particular day. These again are chronological, extending from October to the end of March. We have thus in the communia a record which is being compiled day by day during the Michaelmas term, but the entries in which never refer to any auditing which was actually in hand at the moment of writing. This, however, does not end the contents of the communia. Interspersed in this regular chronological sequence are a large number of entries recording that a fine has been made or is due or has been paid, that the king sent his writ in these words, that so-and-so is not to be summoned on such and such an account, that a writ has been sent to the sheriff, that an account is to be transferred from one membrane to another on the pipe roll, and so forth. It is to be noted that all communia entries have their counties noted in the margin. Now this last section of entries is not very different in character from those which appear on the other membranes, those arranged under counties. Though these latter tend to be distinguished by the use of such phrases as loquendum cum to introduce them, and in a number of cases have notes obviously added to them at a later date. Membrane 8 actually has a space deliberately left for such notes. On the whole, I think there can be little doubt that, while the communia include 1. What are later separate sections in the shape of dies datae and various brevia, 2. Matters noted for reference when some account, not yet auditing, shall come up or in future terms, the county membranes give us matters left unsettled during the auditing of each sheriff's accounts. This close connection of the county membranes with the actual making of the pipe roll is supported by the fact that their entries are found to correspond with cases on the pipe roll, where the essential words of the entry, the debit or redit compotium, are left blank. If this explanation be correct, we have established that the use of the memoranda in John's time, not only for the noting of calendar arrangements made with the accounts, but also 1. For recording all kinds of current business, which was now too voluminous to be dealt with without some kind of minutes. 2. The easing of the calls of auditing upon a limited amount of time by the regular reservation of matters which were doubtful or perhaps controversial. This second difficulty, that of time, was met later almost entirely by the expedient of preliminary audit, of which we noticed traces above. We have not quite exhausted the contents of our first memoranda roll. There remain the small membranes and the Jewish membrane. The small membranes include one which again foreshadows a well-known division of the later memoranda roll. giving us amercements of sheriffs who had failed to attend at Easter and appointments of days for views of accounts. This last is obviously important with regard to the matter of shortening the taking of accounts already referred to, but we have not sufficient details to found suggestions upon it. The remainder of the small membranes are memoranda giving the details of larger sums for which various persons have to account. In a word, they are in the nature of estreats or of particulars, of which we shall have to say a little later. The Jewish membrane is headed Compotus benedicti detalement de debitis et finibus iuderorum Anglii effesto purificationis anni noni regis Ricardi usque ad festum sancti Hilariae anno Johannes primo. It is to be noted that this is not the actual compotus of Benedict, but memoranda upon it. It is particularly interesting from many points of view, but the whole question of the administration of moneys paid by the Jews is so complicated that it is difficult to deal with any sections of it without a reasonable space. We may note, however, that the payments for which this Jew was responsible were apparently not intended to appear, and they did not appear, upon the pipe roll, while on the other hand he apparently did account for them. I have endeavoured elsewhere to show that later, at any rate, there was a distinction between receipts from Jewish talliages and receipts from other Jewish sources, the latter, not the former, being collected by the sheriffs and figuring, though obscurely, in their pipe roll accounts and in the ordinary memoranda rolls, whereas talliage matters did not appear on the pipe rolls and, if they required memoranda, must have had special ones devoted to them. Since the matters here noted are of a very general character and are not yet stated to be subject of a compotus, we may conjecture that we have here traces of an early experimental stage in the exchequer treatment of Jewish administration. To sum up, we have here in this memoranda roll not only interesting foreshadowings of the memoranda rolls we know later, and indications of earlier ones in the same series now lost, we have also certain definite signs of the result upon exchequer administration of the increased size and number of accounts. First, the memoranda of the Dialogus developed into communia, in which were set out in an orderly fashion the various notanda of a busy department, these communia throwing off, as it were, smaller specialized divisions for certain regularly recurrent items, produced the memoranda roll as we know that record, and in the example we have been examining may be found in embryo all the varieties of matter which the subsequent rolls contain. Secondly, our roll shows us attempts being made to meet the second great difficulty of the period, not only the increased business but the consequent increased demand upon available time. In our roll it is met by the reservation of special points. Later it was met by a system of preliminary audits, the adoption of which eliminates the necessity for country membranes which consequently disappear from the later memoranda rolls. It is even possible that we have in our roll an indication of the trying of this method of separate audit also in the case of the Jewish matters. Finally, the memoranda roll of John's first year gives interesting testimony to the fact that all exchequer development turned on the necessities of the pipe roll and its scribes. Elsewhere I have suggested that even the early receipt rolls, though the Dialogus tells us they were made in the lower exchequer presumably for the convenience of that office, were conditioned in all the particulars of their form and making by the necessities of the pipe roll scribe. The same might be said of the country membranes of the memoranda which we have been discussing. Their arrangement, writing, and form all confirm the inference which may be made from their contents. And in the small membranes which we have noticed, what have we but those rolls or notes of particulars the existence of which elsewhere is not infrequently noted by the pipe roll scribe when he has not time or patience to insert their details in his roll? These are the germs of the collection of vouchers by the King's Remembrancer, which has given us our modern class of exchequer accounts, etc. We have dealt at so much length with this important record that there is little space left to discuss others like or connected with it. We may take these in conjunction with the vouchers. It will be remembered that we have to deal with 3 documents from the class of exchequer accounts and one from the K.R. Miscellanea. To these we may add the companion roll to that just described, L.T.R. Miscellaneous Rolls 1/4, but we may eliminate the Miscellanea document, reserving it for treatment with the Chancery Fine Rolls. Taking first the last of these, a roll of about a dozen membranes, with a few smaller membranes or slips, we find we have to notice most of the features which were prominent in the previous example. We have the title Memoranda, with two interesting variants, which suggest a still fluid state. Memorialia and De Memorias on membrane 8, and we have apparently Communia on membrane 1. We have Adventus Vice Comitum under that title on membrane 2. We have the same distinction between Communia entries and membranes assigned to particular counties. We have letters from the king to the barons, M3, and we have again a special section devoted to the Jews, M13, entitled Compotus, though it is really only a number of memoranda upon an account. In this connection we have to note an innovation, for a similar heading on membrane 12, relating to Hugh de Nevill, introduces us to actual rough Compotus, which seems to take us a step toward the use of preliminary audit. This roll covers the Easter and Michaelmas terms of the 10th year of John, with some reference to the preceding year. The whole appears to be an incomplete set of membranes. Two final points to be mentioned are concerned with the use of the word extracta as a title on a membrane, M14, containing lists of debts, and with the nature of the small membranes which are here, as before, to be classed as either estreats or particulars. In connection with this last point it is to be noted that even in the later periods it is very frequently impossible to decide whether an isolated list of entries in the great form de Journal de London V.S. is an estreat from other records showing amounts which are due, or a particular giving the details of sums actually handled elsewhere on the pipe roll, but handled there only in gross. The presence, of course, of the word extracta makes it certain that we are dealing with a list of debts which are to be extracted, but other of these lists, notably the small membranes on the memoranda, are more probably particulars. This may serve to introduce us to a group of rough rolls giving, under a county arrangement, lists of debts which we may conjecture to have been left over at the end of a term of audit and listed for the purpose of a summons for the next saccharium. Indeed, we have, in one or two places, items cancelled with the note Ponetur in submonicione, or in rotulo est. This group includes, besides membrane 14 of the roll just dealt with, 3 documents of the next reign, which we may perhaps mention in passing because they correspond so exactly with 7 membranes and a fragment out of the 22 which make up Exchequer Accounts 505, number 4, a roll in a very bad condition, which is ascribed to our period and may belong to it, though the evidence for this date is not on any of these 8 membranes. It is to be noticed that certain membranes are indexed with a county reference at the foot, and have added the word M, presumably for emendator, or some other part of that verb, meaning, apparently, that the list has to be checked. We are left with the bulk of the roll last mentioned, Exchequer Account 505/4, and with Exchequer Accounts 152, number 1, still to be described. Both are of considerable importance, for they are memoranda of the Norman Exchequer. The first, a collection of 13 membranes and a fragment, was joined by accident to the English membranes already noticed, as we may conjecture, during a search for information about forests, conducted as it appears by an endorsement, a century or so later. However that may be, they are worthy of more study than we have space to give them here. It must suffice to note summarily a few points. Thus they belong apparently to the year 1201 or 1202. Some of them are similar, mutatis mutandis, to the English rolls of debts just mentioned, and have references to the Norman pipe roll and audit summonses. We may note in connection with some of these that the use of the words extracta memorandarum, the last supporting the suggestion made above in connection with the use of extracta in the English memoranda, that these lists were made up at the close of a session of the Exchequer from the memoranda of the term. On another membrane we have memoranda precisely similar to those in the English communia of terms given for rendering account, and notes beginning sciendum or debet respondere, all annotated in the margin with the names of the districts to which they refer. But perhaps most remarkable are 2 membranes dealing with impress, receipts in money and kind, by Warren de Glapion and others, and expenditure at Rouen and other places over a period named, and mentioning the receipt, at the Norman Exchequer, of a rotulus de camera regis. The significance of all this information is obscure, but it clearly indicates proceedings both complicated and varied, showing at the same time a close connection with the English court and distinct individuality at the Norman Exchequer. The other Norman document of a memoranda character is a single membrane having no date. Monsieur Le Gras puts it early in the reign of John. In several places it is entitled Extractus Memorandorum. Also it has a note Amend and another Ponitur in Rotulo. All points connecting this with the documents we have been noticing. It has, however, two characteristics of its own. One is a vertical line drawn through the part to which the note Ponitur appears to relate, a familiar device in later Exchequer procedure. The other is the fact that we have here apparently not so much memoranda for the use of the court as instructions to an official who was to collect the debts. De te ipso is a frequent entry, and it appears that this official, whoever he was personally responsible for a large number of accounts. With this we must leave the question of memoranda and vouchers, of the two exchequers, noting only in passing an indenture which may be presumed to have been a voucher to some kind of account. This last very interesting document, which I believe has not been printed, gives particulars of the contents and disposal of prizes brought into Portsmouth by John's galleys from 25 April to 8 September in his 13th year. This completes, so far as present space and knowledge allow it, our survey of the Upper Exchequer. We turn to the Lower Exchequer, which may be quickly dealt with. Of original receipts, as we have noticed, there is possibly one. The person whose debt is mentioned on this tally, Jordan Nepos Gebrasii, appears in records from the end of the reign of Henry II to that of John. Possibly the writing on the tally makes the later date more probable. Of receipt rolls we have practically nothing. The very interesting roll of the reign of Henry II, with a similar one of the reign of Richard I, which has lately come to light, suggests that the receipt roll was in origin closely connected with the processes of the Upper Exchequer. The handwriting, though smaller, is similar, so is the division into counties. The reign of John furnishes us with an important roll showing the development out of this state, as the present writer interprets it, into that which we find in the early years of Henry III. The John roll, which is devoted to receipts from Jews, was prepared in and for the Exchequer of Receipt. In this roll we find the parchment enlarged, and the writing made smaller than in the previous examples, so that there is space for 2 or 3 columns abreast, though the pipe roll habit of noting the contents at the foot of the membrane still persists. It is this type of roll, with its fuller contents, its summae added at intervals, a matter which would not concern the pipe roll scribe, and its make-up, in many cases, with membranes of issues, which seem first to show us the idea of a receipt roll applied to the convenience of its makers rather than that of the pipe roll scribes. Before leaving this subject we must mention a small roll which has always been classed, in modern times at least, with the receipt rolls, though in character it resembles rather the particulars mentioned above, and though it came to the Record Office from the Tower of London. It will be convenient, however, to reserve it for illustration of a later point. Turning to issues, we have again to note the preservation of only one original, a writ of Liberate, now among the ancient correspondence. It is interesting because there are only 2 earlier ones known, that printed by Dr. Round and that given by Maddox. Like Dr. Round's specimen, it is sent by the Chancellor, presumably in the King's absence. Of enrolments of writs we have no example. The earliest is attached to the earliest complete general receipt roll belonging to the 4th year of Henry III. The earliest example of the later form of roll, which gives only a summary of the writ, belongs to the 25th year of Henry VI. Leaving for the time the question of the records of financial departments other than the Exchequer, we pass to the records which, though belonging to the Chancery, affect either directly or indirectly the Exchequer processes. The first question that faces us is that of the connection between the collections of the 2 countries, together with the possibility already referred to that the Norman set are not homogeneous and perhaps not all Chancery rolls. As to the nature and number of the Norman rolls, as that name was understood in the past, we have little to guide us. We have notice of the bringing of rolls from Normandy, but this does not help us. nor can the conclusions which Hardy based upon an indenture of the time of Richard II. Be relied upon in this particular. In point of fact, one of the surviving rolls is definitely of Norman Exchequer origin. It begins Hic est rotulas Catarum et chirographorum Normanorum factus tempore, Guarini de Glepon senescali Normani, assistenibus ad Scacarium Sansone Abate Cadomi. This is a roll of fines made at the Norman Exchequer and of private deeds, including some charters from Henry II. And Richard, and a number from John, enrolled, we may presume, for safety among the records of the King's Court, a function of the Norman Exchequer of which we have little notice elsewhere. On the other hand, Norman Roll No. 1, which has been added to the series since Hardy's time, is merely the first part, for the month of April, of the first English Liberate Roll, while No. 7, which was printed by Hardy, is a roll of the values of the lands of Normans in England after John had lost the duchy. Of the remaining 4 rolls, No. 2, to John, entitled De Oblatus Receptus, corresponds closely with the English fine rolls, but relates to Norman affairs. The Et Mandatum Est, when it appears, is addressed to Norman officials, and there are interesting references to summonses to the Norman Exchequer. Roll 4, belonging to the same year, is called Rotulus de Contrabrioibus. The meaning of this is explained below. For the moment we need only observe that the writs are generally addressed to Norman officials or else to persons abroad, while on the other hand the dates of the last membrane of the roll suggest that it was made in England. No. 5, for John, is a Rotulus terrarum liberatarum et contrabrium, the dating of which writs enrolled here, save at the beginning, is abroad, and itself was presumably made abroad. The references, too, are clearly to Norman administration. We have a special note of a matter quod debet scribi in rotulo Angli. No. 6, 5 John, is a similar roll to No. 5, and it is to be noticed that a fragmentary 5th membrane, added in 1838, has never been printed. The addresses of writs on this roll are generally Norman, and the dates all Norman, save 4 at the end, corresponding to John's return from Normandy to England in this year. It seems clear that these 2 English-dated writs are only included on the roll by mistake. A mistake in the other direction has a special note, in rotuo Anglii totum bruei. Now from a later experience of the Glasgow rolls and other special chancery enrolments, we may remark that a special roll of this kind may either be 1. A roll of letters dated abroad, or 2. A roll of letters referring to foreign matters, whether these appear in other, ordinary enrolments or not. What is the principle on which the Norman rolls were made? There is no serious doubt that at this date the chancery still, as a rule, followed the king. There is a prima facie case therefore for making the Norman roll a roll written in Normandy. I think this conclusion is made almost certain by the ending, already noticed, of Norman Roll 4. On the other hand, the personal touch of the king being still strong in affairs, it is not unreasonable to suppose that Norman affairs would rather monopolize the attention of his chancery when he was in Normandy and English ones when he was in England, provided, of course, that he was in any given year dividing up his time pretty fairly between the 2 countries. This probably resulted sometimes, by confusion, in a belief that Norman entries should go on the Norman roll, resulted, that is, in the interpretation of this roll's function upon a subject basis, so that we get contemporaneous rolls of English and Norman Liberate, find upon an English Liberate roll Norman entries cancelled quia in roto Normani, and have, as has been seen, one Norman roll actually compiled in England. The confusion would go so far that the Norman-made rolls, composed, as we shall see, entirely of entries having a financial interest, would be preserved in Normandy in the interests of the Norman Exchequer, although, unlike the Exchequer rolls, they did not owe their existence to a separate body of scribes. This would explain the presence in the modern series of the Norman Exchequer roll noticed above. End of section 17. Section 18 of Magna Carta Commemoration Essays. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by MaryAnn. Financial Records of the Reign of King John. by Hilary Jenkinson, Part 4. Turning to the question of the contents of these rolls, we may say at once that they do not differ generically from the English ones, so that the two sets may be treated together. Taking, then, the Norman and English Chancery Rolls, which are of direct Exchequer interest, we may divide them into two classes, called for convenience Liberate Rolls and Fine Rolls. The first of these classes contains entries of writs of liberate for payments at the Exchequer, as also some writs of pardon, of computate, and of allocate, addressed to that department. The Fine Rolls, alternatively called oblata in early times, contain entries of the sums paid to the king, so and so dat domino regi, so much to obtain various privileges, licenses, and exemptions. The ways in which the scope of this roll was developed and modified later need not here detain us. Our Exchequer interest in the two classes resolves itself into two questions. 1. How far do these rolls relate to the business of the Exchequer, and how far to that of the Camera? 2. How was the information in them imparted to Exchequer officials? Let us take the Fine Rolls first. These rolls are certainly compiled in the Chancery, not the Exchequer. This is made clear by plenty of notes such as hinc mittendum in Scaccarium. It is equally clear that certain entries, at least, have a definite Scaccarium interest, and we have references to the Pipe Roll. It is clear again that the documents used by the Exchequer were not our rolls, but copies, for we get such a note as this: Finis iste non debet mitti ad Scaccarium hic quia mittitur superius. Moreover, it appears that in spite of the dat domino and the title of the earlier rolls, Rotulus Obularum, or Finium Receptorum, the money was not always, at any rate, paid on the spot. This appears by the following among a number of entries: Cives London dat domino regi 3 Macarum pro habenda confirmatione, et carta liberabitur Galfrido filio Petri per sic, quod si illa volunt dare suam cartam, habebunt si non autem cartam non habebunt. On the other hand, the interest of the Fine Roll entries is not always for the Exchequer, for we have such notes as non mittitur quia foresta, and if the dat or the receptorum ever have a literal meaning, it is difficult to see how the Exchequer could need or profit by information concerning the entries on these rolls, unless we are to make the difficult assumption that the Chancery staff were at this date subjected to audit. We may perhaps make tentatively the suggestion that entries upon the Fine Rolls fall into two rough classes of cash payments and promises, only the latter engaging the attention of the Exchequer. This opens up possibilities too wide for discussion here, though we may perhaps say a word on the subject later in connection with the Camera. Like the other printed volumes of John Records, the Fine Rolls offer scope for careful reading and analysis. In conclusion, we have to add to the known Fine Rolls what is, though rough and written on an unusually narrow membrane, undoubtedly the fragment of a Fine Roll of the 12th year of John, 1210. It came originally from the treasury of the Receipt, but it is not unknown for Chancery records to be found in the repository. It is now among the Miscellanea of the Exchequer, K.R. 1, No. 5. Turning now to the second of the classes of Chancery Rolls to which we alluded above, the Liberate, we have to deal with three Norman Rolls proper, one Norman Roll which forms the April section of the English Liberate Roll for the 2nd year of John, and English Liberate Rolls of the 2nd, 3rd, and 5th years. Further, it is generally admitted that this series is continued by the Close Rolls, which begin as has already been noticed with the 6th year. It is possible that the loss of Normandy and the elimination of the necessity for a double series of Liberate Rolls and double reference to two Exchequers had something to do with the innovation. If we include the Close Rolls in the division we are now considering, the principal question facing us is what parts of the contents of the rolls would interest the Exchequer. Now the contents of the Liberate Rolls proper are writs of which the originals, by their nature, are bound either to be found in the Exchequer at the time of audit, or to be produced there by accountants. The only use for the Chancery records of these, so far as the Exchequer is concerned, is that mentioned in the Dialogus, the checking of the originals by means of the Contrabriua or Rescripta, which themselves, not in the shape of secondary copies, are brought over by the Chancellor or his clerk. It is by no means impossible that, in contradistinction to the fine rolls, the actual Liberate rolls still preserved to us among John's Chancery rolls themselves visited the Exchequer. Certain annotations upon them may even have been made in the Exchequer. If the Chancery Liberate rolls were periodically sent over in this way, it would account for the fact that no Exchequer enrolments of these writs have come down to us for the John period. It was not till the receipt officials came to make rolls for their own convenience that such an enrolment came to be thought desirable. To the Liberate rolls, then, representing the Rescriptum of the Dialogus, we see added to our period, e.g. in Norman Roll 5, entries of terra liberate, that is, copies of letters which indirectly interested the Norman Exchequer. Similarly, in the English Liberate Roll 3, we have the title Rotulus Terrarum et Denariorum Liberatarum in Anglia. Once again, then, I think we have here, as in the case of the receipt rolls mentioned above, the Exchequer, interest originating the keeping of rolls in another department. This other department speedily finds out the convenience of preserving such records for its own purposes, and we have added to them copies of documents, in the present case other letters close or patent, which are not, in some cases, even indirectly of audit interest. From this the transition would probably soon be made, in the case of the Chancery, to an ordered treatment of the subject from a Chancery point of view, and we then get added the idea of originalia or estreats made specially for the benefit of the Exchequer, and incorporating transcripts from the fine rolls, with less numerous items from the close rolls and the patent and charter rolls. It is not improbable that the duplicates surviving to us in the classes of both fine and close rolls of the John period are relics of the transition stage, but here again is a subject too detailed to be dealt with in the present paper. We have in fact in the time of John at first two distinct collections being made by the Chancery. 1. Enrolments of charters and letters patent, of which letters copies were preserved for the purposes of the Chancery. 2. Liberate, preserved primarily for Exchequer purposes. As this second class merged into the close rolls, the Chancery interest in the preservation of record of letters close became equal, at least, to that of the Exchequer. The stage before this is possibly responsible partly for the lack of exactitude which we sometimes notice in the early rolls in the assignment of a letter of one or the other kind to its proper class of enrolment. We have left till the last the most thorny of all the questions connected with early financial records. Contemporary reference gives us, as administrative instruments, the Saccharium, the Thesaurus, the Recepta, the Camera, and the Garderoba. What are all these, and what their relations one to another? Various writers have touched upon this one and that, and have even alluded to points in their relationship. Thus, Professor McKitchney suggests that though the audit was fixed at Westminster, the Exchequer, in which he includes presumably the Upper Exchequer and the Recepta, with much of its impedimenta of writs and tallies, would accompany the king. Delisle, speaking of Norman affairs, says, La chambre suivant le prince, le trésor, restrait en dépôt et en château, Falaise or Caen. Professor Powicki, dealing with the Norman Exchequer, speaks of the English Exchequer Chamber so far as that did not follow the king. In dealing ourselves, so far, with existing Exchequer records, we have been able to trace in John's reign a number of the series of Exchequer records which are familiar to us at a later period, and to trace, too, something of their relationship to each other, and to the most important of all, the Pipe Roll. We have even ventured to suggest what were some of the matters of difficulty, the points of pressure and congestion in the old simple system of receipt, expenditure, and audit, and in the records of these processes, and consequently what signs of development and growth we may look for in our period both in the system and in the records. We have refrained, however, so far from an attempt to fit King John's known financial transactions, as they are reflected in innumerable instances in, for example, his Chancery rolls, into this or that part of the machinery we were able to outline. We have been content, that is, to allude to the fact that the pipe roll and other machinery does deal with some financial matters, while others pass it by, without attempting either to classify the first of these or to collect concrete instances of the second. Unfortunately, we have financial records still to deal with which touch the second of these classes, the mise and prestita rolls, which are undoubtedly concerned with some transactions that are outside the normal course of the Exchequer and the normal pipe, memoranda, receipt, and issue records. We are driven, therefore, in conclusion to touch upon the record evidence for the administration of financial matters which did not come within the influence of the Upper Exchequer. We have already suggested that because a matter was not subject to audit, there is no reason that the receipt and issue side of it should not be controlled by the Lower Exchequer, whose business these processes were. Unfortunately, the paucity of records of this department for John's reign does not permit us to prove or disprove the suggestion that the receipt was still giving itself little trouble over matters of which the pipe roll scribes did not take cognizance. In opening this matter, it is necessary to distinguish not so much between the camera and the sacrarium as between the camera and the curia. It is to be remembered that the curia is originally the personal entourage of the king. The camera only appears when the curia has been professionalized and departmentalized, supplying that personal element which the curia had lost. Thus, in administration, when the king's secretary has become the department or court of chancery, there arises a new personal secretary, a member, as the chancellor had originally been, of the king's household staff. Similarly, the treasurer, departmentalized, is replaced from the personal point of view by the keeper of the king's private accounts, in the contemporary phrase, keeper of his wardrobe. We have to note first, then, that the camera is not a purely financial affair. It is the successor of the curia in the position of the king's personal entourage. All kinds of duties, certainly secretarial as well as financial ones, may be undertaken by it. The unfortunate anomaly of John's reign is that the chancellor has not been departmentalized, whereas the treasurer has, so that we have this member of the curia still following the king and, in effect, a member of the camera. Later he will be replaced there by the keeper of the privy seal, but at present that instrument is no more than a signet ring which the king uses, normally, in much the same way as any private person. We may now attempt some distinction between the financial terms mentioned at the beginning of this section. In the first place, the sacrarium, apart from its literal sense, should undoubtedly be a season, an occasion, the occasion or season of audit. Unfortunately, there seems little doubt that in early times, while this is the generally accepted sense, the word is sometimes used loosely. Maddox has collected together several instances of what appear to be local sacraria, according to him, some subordinate receipts or places of revenue, with which he classes the Sacrarium Redemptionis Regis Ricardi and the Sacrarium Aronis, which dealt with the debts of Aaron of Lincoln, and also the Sacrarium Hugonis de Neville, to which a certain debtor was ordered to pay £700, on the understanding that Hugh de Neville would account for the sum afterwards at the Sacrarium Westmonasteriii. Most of the instances given might be explained as being special occasions, but this last of Hugh de Neville is difficult. We may add to it a reference to John's Sacrarium de Merleberg at Easter 1207. The payments which are ordered to be made there appear to some extent in the normal pipe roll of the following Michaelmas, so that we might suppose that on this occasion the Easter Exchequer sat, exceptionally, away from Westminster. We have to add to this, however, that a little later on, in July 1215, Hugh de Neville was keeper of the king's thesaurus at Marlborough, that the small so-called receipt roll mentioned above is a short list of sums received de ballivis Hugonis de Neville, unde responsum est ad Sacrarium, and that in the pipe roll of the 10th year we have a compotus Hugonis de Neville de recepta sua. It is possible that we may draw from these passages the inference that yet another expedient was tried during our period for the relief of the overworked Exchequer, an extension of the principle of compotus and particulars in the shape of supplementary provincial exchequers whose activities were summarized at the audit at the Sacrarium Westmonasteriii. Be that as it may, it is clear that we must be prepared for the use of the word saccharium in exceptional cases in a sense closely similar to that of thesaurus. About the function of the thesaurus there is no ambiguity. Its business is the custody of treasure, including records. It frequently follows the king, but sometimes he deposits its contents in some place which is considered safe, such as the Abbey of Reading. On the other hand, it sometimes remains apparently in places difficult of access. It is possible that the term was applied to more than one depot of treasure, for we have reference to the king's receipt at Shrewsbury of a large sum from "our treasury of Marlborough," but this may have been only a temporary localization. Did the officials of the Recepta, who normally controlled the thesaurus, follow the king? If not, there must always have been a thesaurus, though it might be empty, at Westminster. In any case, there is no reason to suppose that the thesaurus or thesauri, though it, or they, certainly should receive moneys paid in and audited in the old normal way, did not also include any moneys the king might have accumulated by other methods. The camera as well as the saccharium may have been, so to speak, a depositor. There is no doubt that the king did receive, irregularly, large sums which were paid over to him wherever he might happen to be. This is to say that he received them in camera, in his household. Sometimes they were sums which formed part of a regular pipe roll account, and the barons of the exchequer have to be notified of the receipt. Sometimes they are dona, or fines, many of which certainly did not figure in any known audit. Sometimes they are sums derived from the thesaurus. We have numerous instances of such receipts in camera or in guardaroba. Do these two phrases convey the same thing? Probably the explanation is that anything paid in guardaroba was necessarily paid in camera, of which guardaroba was only a part. This brings us to the question of the prestita and mise rolls. Of the contents of these rolls we have not space to say much, and indeed their relation and distinction may perhaps be sufficiently illustrated by a single quotation from a prestita roll. Iadam Dei ibidem rogero vocalin, de prestito ad nueam suam omnio parandum, vi Marcus, praetor donum quod rex ei dedit di alies, vi Marques qui sunt in rotulo mise. The interesting point to us is the question of their place in the general scheme of administration, and, since the relation to the pipe rolls, if there is any, cannot be settled with certainty while those records remain unprinted, this is largely a question of the persons who produced them. To that question there can, I think, be only one answer. Even if relations can be established later upon some points with the saccharium, it must remain clear that these rolls were put together in and for the benefit of the king's camera. The prestita are really only a development of the expenditure side of the guardaroba, the more normal manifestation of which are the mise. Both are part of the king's personal expenditure, and since the king's personal writing officer was still, as we have seen, the chancellor with his staff, we can hardly avoid the conclusion that Hardy was right in classing the mise and prestita as chancery records, and that they are incorrectly placed in the exchequer because the latter wardrobe accounts, which they anticipate, went there as a result of the later arrangement by which the wardrobe was made subject to audit. In the chancery they form part of a class, we might conjecture, which on the side of receipts includes the very curious fine and oblata rolls. In this connection we may conclude with 3 further citations from the patent rolls, which speak for themselves. 1. Sciatus quod quietum clamavimus delectum et fidelem nostrum Philippum de Luci de omni prestito quod ie facimus et de omnibus receptus quas recepit dum esset in camera nostra. 2. Littera ista, i.e., originals of enrollments on the patent roll. Liberate erant in camera Domini Regis Rudolpho Parmentario apud Craneburn. 3. Sciatus quod recepimus per manum R. Pioris de Reding omnis rotulus nostras de camera nostra et sigillum nostrum et rotulus nostras de Saccario. No doubt the phrase Rotulus de Camera refers to the mise and prestita, but where are the chancery rolls, the records of letters which had issued under the sigillum? It is tempting to include them also under the same designation, for to the Camera at this date they did, in a sense, undoubtedly belong, inasmuch as we must hold it to have included that Chancelleria which still followed the king. A study of the way in which John's cash resources were handled, passing from England to Normandy, from the exchequer official to the soldier, from the Camera to the Recepta, would reveal, I think, the fact that so far as he had them he disposed of them at his will freely. He may have lacked both money and men, but whatever his servants were they were not his masters. Similarly, behind all the administrative confusion of the reign, the loose ends of old processes dying out, new ones beginning and tentative ones lapsing, we seem to see working a single very powerful administrative brain. Was that the brain of King John's? End of the Financial Records of the Reign of King John. And end of Magna Carta Commemoration Essays by various authors.